Good morning. Good morning. It's Tuesday. It's October 29th. It's towards the end of spooky season. I have my vampire Rolling Stones shirt on, which is maybe a little bit of a nod to the last trial we covered because we have to have a little vampires. I should have worn my Twilight shirt. Maybe on Thursday. We'll get. No, I got a Beetlejuice shirt for Thursday. We'll see. Thursday, just as a heads up, Thursday, we are just doing food court. We are doing a happy Halloween food court. We are going to talk about, well, we'll do some courts of public opinion. We will have a vigorous disagreement in the chat over Halloween candy, and we will have a lighter food court stream. It's been a minute. Next week, I am going to be doing a music stream. There's a bunch of music lawsuits. There's that 50 Cent lawsuit we never circled back on. Some of you remember what we're talking about. That's what we're doing on Tuesday. The mods will be vigorously yeeting any political discussion. We are doing a whole, we're going to be in community and just talk about something else on Tuesday. That's what we're doing on Tuesday. So for those of you that have already voted or are going out voting, we can have a conversation about music lawsuits next week on Tuesday. Today, we are going to be talking about Donna Adelson losing another set of attorneys. Cause what? Oh boy. And then we're going to go over the judge smacking down Carrie Morrissey's ill-advised motion. And I am keeping an eye on what's going on in the YSL case. I saw a comment quickly. I was overwatching Lead Attorney's channel. Lead Attorney gets rowdy, and I think it's absolutely hilarious, but also is really insightful into the law and has been following along with what's going on in the YSL case. Also lives in the ATL. So this is a local case. I also tuned into Lead Attorney, who was in court day after day for the Tasha K. Cardi B defamation suit down there in Atlanta, and is just doing great coverage over on the YouTubes. And I know there's a ton going on, but I feel like we're in a holding pattern today. So let me give you let's do the intro. Let's give a quick rundown, but I think Lead runs an incredible channel and just has content creation absolutely dialed in. So Lead is, look, as I said, Lead can get rowdy, but again, some people don't love my cursey words, so they bounce out of this chat because they don't like the cursey words. So anyway, Lead's got you guys covered if that is the coverage that you're looking for. But Lead's not going to hold any punches at all. So there is 100% that. But lawyers kind of find a way to rock with everybody, unless somebody comes for them. And Lead's always been a good human. So we're going to talk about what's going on in YSL really briefly. I'm keeping an eye on it. Then we're going to get into the other stuff we need to catch up on because, well, we need to catch up on it. And I think it's wild that Donna Adelson's losing more lawyers. And I thought you guys might be interested in the legal wrangling going on there. As I continue catching up with the docket, we're going to be talking more about all of the legal filings in Corey Richins. We're going to get into that early in November because she has a hearing coming up in November that we're going to cover, and hopefully the stream won't get yeeted in the middle because that's the Richins case. That is not KUTV doing that. That is their parent company. Hopefully that's all been resolved and we'll be able to cover the Corey Richins case, but that's going to be coming up in November. So I'll be getting into that as we're closer in time. There's a whole bunch of motions. We'll spend a day in Corey's world and just go through it. So that's what's on the docket for today. The Adelson stuff, I was so tempted last night to read it. I cleaned the office yesterday. The office needed to be I don't know. It needed an exorcism after covering the Sarah Boone case. I was not expecting all of those videos. They were a lot. I think they were a lot for everybody, but those videos were a lot. The office needed Sage and Palo Santo and you know, the cleansing power of Ramstein or something. It just needed everything. So that's what I did over the weekend. As I was binge watching Twilight. On the office TV where I normally put up court. I was binge watching Twilight and cleaning my office, and We've cleaned, like we moved furniture and vacuumed and cleaned and opened the windows, and it feels much better. But I will say, as the office got cleaned, I did take everything that was everywhere and like put it into the guest room. So there's lots that needs to be gone through. I have tons of mail that I need to open from you all, and maybe we'll do some of that on some of our lighter streams coming up. We all need some lighter streams. Jolene said Kristen Stewart is painful to watch. It's getting worse to watch the older I get. I'm like, I loved the books. I think going back now, I would be like, I don't know. It was a time. It was a moment in time, and I think I read was I in law school? Was it a little after law school? Like the Twilight books were so light when I was dealing with so much heavy that I have a very positive association to that time in my life when that was like light and escape and easy. And now I watch it and I'm like, oh my God, all of you shut up. So there's that. But the movie series that I will binge watch are normally things I've seen multiple times and things that I know what's happening and can just like dive into easily. So in those lists of movies, the Twilight series is in there. Most things from the Marvel comic universe, except for the last Spider-Man movie that always makes me cry. Can't. Then all of the Pitch Perfect movies. Maybe it's just Anna Kendrick that's the thing. Maybe that's the key. Maybe Anna Kendrick is the key. Pitch Perfect movies are up there on the light and easy binge watch. Bring It On. Just stuff that is kind of fluffy and good background noise, because yes, the Lauren says ADHD needs background noise. I need background noise and I need to know what it is. And I need to have listened before. I was trying to listen to my book, but I've gotten to the point in a book series where I have not finished. Like I kept falling out of a book series in the same place and I fought through that place. But now I can't listen to that and do other things because I'll forget what I'm listening to. Anything Elle Woods. So yes, the Legally Blonde movies, Sweet Home Alabama. So there's lots. But with all of this, we're going to get into stream today. We're going to talk about all the things. We'll get into Q&A. I want to zoom through our legal filings. And then if we need to decompress a little more from Sarah Boone, we can. It's heavy. That is a heavy case. Even talking to prosecutors who tried those types of cases, the videos are incredibly visceral. And the videos from her phone are different than like body cam footage. The body cam footage was a different kind of visceral, but it wasn't like the body cam footage was a mad type of response, not as much of a like sad, like just deeply heavy sad. And the videos from Sarah Boone's phone were deeply heavy and sad, and just there's so much tied into that with not just addiction and codependency and Sarah Boone's own personality stuff. Because I think had they taken a deeper dive into that, they probably would have found more, but they didn't. But you can see it, right? There's times when those, as you become familiar with, especially those narcissistic traits, you can just see it. And so it was really hard. So this community was great about it, but it was hard. It was hard. So if we need to decompress a little bit about that, we will when we get into Q&A. But it's hard to watch. And for a lot of you, I'm sure it triggered different parts of your life. And we see in cases, especially when we see abuse cases, oftentimes you see physical abuse and you hear about the types of controlling abuse, but you don't see it. And it is a different thing to hear her voice, to see her ripping up his birth certificate and stuff like that. It's incredibly difficult. And I think for some, it's like too close to home from things you've experienced in your own life, which makes me also incredibly sad. But it also, hopefully in some way, it's not just me. Like this happens to lots of people, unfortunately. And hopefully it's easier to see those red signs or those red flags when you are out of it watching in. And I think it was a really important trial for that reason. But it was intense and it was sad. So, all right, Dawn, Marie said, don't let the bad juice. No, we're not. I feel good. We have cleansed. We are good. It just needed, look, sometimes the power of cleansing. And when I joke about heavy metal being cleansing. Look, man, it works. It works. It does. Sometimes it's Slipknot, sometimes it's Metallica, sometimes it's, System. It just is, sometimes it's Tool. It just depends on the drums you need. Or at least that's me. And then I bought tickets for my oldest, my husband and I, to go see Creed. So I feel like we're going to get a full body cleanse soon. So it's going to be great. It's all good. Emily, is live music the thing that you will spend music on or money on the most? That in purses. Yep. Experiences and handbags. Everything else, it's like, nah. Well, and the new docks. Well, they were not on the top end of expensive, but docks. Jolene asked, had I ever taken the boys to Dave? Travis and I have been to Dave. Travis and I had a very unique Dave experience. Travis and I have been to Dave. G has some sound sensitivities and enjoys like music theater performances, but concerts are not his jam at this point, even with headphones, even with in-ears, even with all of the things. So he prefers, I think we're going to go to see Weird Al, but he prefers like musical theater performances. So when we've seen stage performances of Aladdin or Frozen or what have you, he really enjoys that. He enjoys music, but live concerts are still a little much. But we'll see as he gets older. So we'll see how that goes. For those of you asking, Weird Al is touring. Yes, Weird Al is back out on tour. And I think Griffin at 12 loves Weird Al enough that it'll overcome his nervousness about live music. So with all of that, Jill, I promised the members I would show the new docs, and I haven't yet. And I will, I'll share that when we get to Q&A. So I'll share those a little bit. They have stuff. So let's roll the intro and let's get into it. Friendly Farm Girl, my youngest plays trumpet. My oldest has played guitar, but is in color guard because throwing rifles is cathartic. Let's get into the actual stream, and today's going to be like this, but we're going to talk about Donna Adelson and see if we get to any Audacity. That's my goal. We'll see. Are we going to get to Audacity? Are we not going to get to Audacity? What are we doing? Let me know where you guys are coming in from and what you're drinking. I've got a, pumpkin cream cold brew for another few days. Look, we go from like pumpkin cream cold brew season to pumpkin pie season. And then by the time we get to December, I'm like, this year I feel like maybe I'm going to be ready for the peppermint season. Maybe, dare I say, maybe we're ready. All right, let's roll it, guys. And let's talk about some cases, shall we?
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Okay, let's do a quick overview of what's going on. And when I say quick overview, I mean a quick overview of what's going on in the YSL case. For those of you that have not followed this case, I understand it is a shit show. I am still surprised and will remain surprised that this case has not been declared mistrial. I think when I first started covering the nonsense that was going on in this courtroom, I was like, this should be a mistrial. Last week, sometime, the court was inclined to maybe grant a mistrial, but not grant a mistrial with prejudice, which means this could all start over again, which means all the defendants that are in custody stay in custody, and most of them have been denied bail multiple times. Some of them have other charges pending, some of them don't. When you have other charges pending, it's not a surprise you stay in custody. If you don't have any charges pending, it's like, what? The YSL case is a massive RICO case that has been convoluted. I don't think the prosecutors even know how they're proving this case. And there's been issues with the prosecutors. There's been issues with the judge. There's a new judge in the middle. It is wild. And I have covered a little bit of that on the Emily Show podcast and on Quick Bits. So if you have the audio feed, you'll get all of that. But the prosecution is trying to use the RICO statute to go after rapper YSL and the music label, saying that it was operating as a criminal organization, similar to the way they've done in R. Kelly, but different charges. This is more gang related and similar to the way they're doing in Diddy, but again, different charges, more gang related. So by more gang related, I mean less trafficking, even though gangs are starting, well, and have been into trafficking, but weapons and narcotic sales and shootings and homicides and that. So they're going after this massive RICO case. There were initially 28 defendants. 6 of them are currently on trial. Multiple times, it looks like there's going to be mistrials. Defense attorneys got thrown in jail before trial, during trial. And now it looks like on the precipice of another mistrial request that might be granted. It looks like there might be plea deals for everybody, and they are working those out today. So it looks like they are working out plea deals. Who will plea? Will there be pleas? Will this trial resume? I don't know. But the prosecution has run a terrible case. It has been wild. And I still don't know how this hasn't been a mistrial, but when there's a mistrial, it's rare that there is a mistrial with prejudice, like in Baldwin, which we're going to talk about real quick. So it just starts over again. It took them almost a year. It took them 11 months to pick a jury. This case is going to go through trial into 2025, and opening statements started in November of last year. They're almost a year into trial. 11 months of jury selection, and they're 11 months into trial now. 22 months this has been going on while these defendants are in custody. It's wild. So for a couple of you asking, what is RICO? RICO is the racketeering statute. It was originally conceived of to get to the crime bosses of the mafia. So it was to go against the mob. And the problem they were having with the laws at the time is that oftentimes you would have the higher ups in the corporate structure that is the criminal world telling people what to do, and those people were doing things, and then those people were getting prosecuted. But the people at the top that were making money in the shot collars, they weren't getting prosecuted because they weren't doing the things. And so instead of trying to bring that all in with conspiracy, because sometimes it's hard to prove the agreement that's had, they started the racketeering structure to show that the organization is engaged in criminality. That's the purpose of the organization. And then they could kind of go up the chain to get to the higher ups instead of having to use tax evasion and that kind of stuff. So it's what they're using against Diddy in the criminal prosecution. And racketeering is just a massive, wide open space for federal prosecutors. And for state prosecutors, they don't use it as much, CEG, Georgia. But for federal prosecutors, it allows you to bring in all of these acts that aren't charged. So instead of charging it as this person did this thing to this person, it is this organization did this thing. And this one person, who might be a lower level person in the organization, did a thing. But the person at the top of the organization is overseeing all of this, and it's for the benefit of the organization. So they can bring in acts that they might not have charged independently, and they can go all the way back to show a pattern. So in like the Diddy case, they're going to go back maybe decades to bring in different acts to show that the organization is ongoing, even if those things are past statute of limitation, et cetera, et cetera. So they can now use it to show everything they've been up to in a much broader way. So it is wild. EB in the chat said YSL watchers have bonded in our court trauma. I text facepalm 20 times a day. I've never seen it. And I am particularly picky with white collar crime cases. So anything in your fraud range, your RICO, your conspiracy, all of those large fraudier crimes. I loved trying those kind of cases. There is so much room to be organized and to color code and to have binders and folders and tabs and which predicate acts go to which witnesses. This prosecutorial team seems to be figuring it out like day by day. Like, who knows? So no wonder there's no there's no direction in this case. I don't think the prosecutors know where they're going. They're just driving around in circles without a map. It's awful. All the accordion folders, like accordion folders with like tabs in banker's boxes. Those kinds of cases take time to organize and they take energy to organize. But if they are executed well, they are great cases to try. I think we'll see that in the Diddy cases. Oh, we binged. Look at us. I think we'll see that in the Diddy cases. We saw that in the R. Kelly cases. But in state cases, we don't see a lot of RICO cases. It's not used as often at the state level. And if you want to hear me break down RICO and YSL, it's on the Emily Show. So if you put in YSL and you search my channel, you'll find it. So Sheila said, wait, you have to have a plan beforehand? Yeah, like a lot of one, like a lot of a plan. And I think we saw it in Sarah Boone, right? We saw the plan ahead of time and we saw it when we got to the rebuttal arguments. You could see the plan come together, right? You're like, that's their plan. Why did they never talk about the suitcase before? So nobody could give another explanation. They had a plan from opening to close. They had a plan. They knew what they needed from each witness. Very short testimony from some witnesses. They knew what they were bringing in and they knew with her defense what they were bringing in the rebuttal. And it was just like bing, 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 bing. That was it. All right, shall we bing? Shall we bing? Chat, we shall. And then we'll talk Baldwin briefly. And then we've got the rest of the day talking about Adelson. And I'll give an overview. If you guys don't remember the Adelson case, I'll give an interview. Oh, it binged. Move your head. Ah! Not an interview, an overview. I'll give an overview. Emily, is your brain still tired? Yes. Yes, it is. Yes, it is. Yes, it is. So I think we saw really well in Sarah Boone, prosecutors with a plan. I really do. And you notice those things. For those of you that are just noticing the pumpkin, look, man, this is Halloween. This is Halloween. This is Halloween. We're going to celebrate. It's Halloween time. I've got we've gone vampire for the Rolling Stones shirt, which was actually a really fun concert. My parents came out and we all went to Rolling Stones together. It was a really good time. We're ready. We're going to do a fun, maybe shorter stream on Halloween. And we're going to do, music next Tuesday, and then we're all gonna just I don't know, breathe into a paper bag or something, because everything feels tense. But we're gonna just be law nerds here, and we're gonna talk about other stuff. All right, order denying state's amended motion to reconsider dismissal with prejudice. This is coming from the Baldwin. Oh, I should do an orientation of where we are at. Let's do that first. You remember Carrie Morrissey made that motion and I was like, literally, what is the law here? Like, is that lawful law? Because Carrie Morrissey asked the court to reconsider the dismissal of the Baldwin case with prejudice. I'm like, I don't think there's law for this. I don't even know if the court still has jurisdiction over it. Like, I don't even know. There's no law for this. And then Carrie Morrissey didn't cite law. Her motion was like, but like, Your Honor, you don't understand. It's not fair. You don't understand. These are the facts. See it my way. And Baldwin's attorneys were like, no. And now the court's like, no. So she asked the court to reconsider the dismissal with prejudice. I don't think legally there's any law that allows you to do that. Then she asked the court to reconsider the yeeting of the motion that was over pages. And then she asked the court to reconsider something else. There were like three, but I know my motion is like 52 pages, but can you please allow me an extension? The court's like, no. And she's like, but I know this is, can you allow me? No. So she kept pushing and pushing and pushing and pushing, and the court did not hold a hearing on this. So for those of you that are like, hey, did we miss something? No, we didn't. The court never sent a hearing. There was no hearing set. The court ruled on the moving papers because there is no law here. But she was trying to relitigate the facts over and over and over. And it was like, why won't you see it my way? Why won't you see it my way? Why won't you see it my way? The court does not agree with you, Carrie. She's like, but it's not even relevant. It's like, well, it might not have been if you had turned it over, but you didn't. The Lauren said, so Alec Baldwin can't be retried, right? Not a criminal trial. Nope. Nope, he cannot. All the civil stuff is still going to go on. And then the chat, because the chat is wise and witty, said, this is not a motion, it's a meltdown. And I was like, ding, ding, ding. It was not a motion. It was, in fact, a meltdown. And now we've got the court's ruling. And I put this on pause because I wanted to read it for the first time with y'all. It is the worst scanning of a document I've ever seen. It's not you. It's not your TV. You don't need your eyes checked. It is this freaking motion. It looks like that. That's not you. Boo. That's not your TV. That's not your YouTube. It is the worst scanning of a thing I've ever seen. Like ever seen. Paul Young said, any relevance to Hannah's case? Not really. Hannah's attorney tried it to say, hey, you dismissed Baldwin's. If you're giving out dismissals, can we get one of those too? But it's a different standard. It's a different procedure in trial. And Hannah's lawyer is now appealing. So when we get to Hannah's appeal being in, we'll probably go through those all together. That would be my preference at this point, to wait until Hannah's documents are in and at least the state's documents are in, and go through Hannah's documents and the state's documents together and do an overview instead of like a line by line of those, because it's going to be the same thing that they've argued before. And so we'll do an overview. There's some, maybe we'll do that on Tuesday as well. Maybe we'll do music and Karen Reed. Let me look at the calendar real quick. Karen Reed has a hearing coming up. And if we can go over this, we didn't really go over the state's response. Maybe we'll do that Thursday. We'll go over Karen Reed on Thursday the 7th, because then that'll get us out ahead of her hearing. Her hearing will not be streamed. There might be audio access. I'm going to try to figure that out. I don't know if audio access will be able to be streamed, but if it can, I will. If it can't, I won't. I do not, when courts are like, you can't, I'm not ever going to be the lawyer that's like, but what are you going to do to me? I'm like, nope, the court said no, I'm going to respect that. So that's always my choice. But if I can attend, I will, and then I'll break it down for you. And if it's streamed, we'll stream it. But she has a hearing coming up at the beginning of November. And so we'll cover what was in the state's response next week. It can wait a week. It's going to be same. It's going to be same. All right. Order denying state's amended motion to reconsider dismissal with prejudice. Can somebody tell me how this is even lawful law? Like how? Rachel, Kivity's trial got kicked. I don't know the date it got kicked to, but it got punted. But we will cover Kivity when it comes up. But it got booted out a little bit. So it's not, I don't think anything's going to go to trial between now and January. Our next trial might be Karen Reed again, but I think they're going to try to get that put over, but we'll see. So, but there's been lots of delays. Trials don't normally go when they are set. They normally get delayed. Let's see. This matter came before the court on the state's amended motion to reconsider dismissal with prejudice, filed September 5th, 2024. Having reviewed the briefing and being otherwise fully advised, because the court was in court, note, no oral argument. The court finds, concludes, and orders. Procedural summary. On September 5th, the state filed its amended motion to reconsider. Thereafter, on September 20th, Baldwin filed his response. In turn, on October 6th, the state filed its reply. The court denies the state's amended motion for the reasons set forth below. The state's amended motion advances arguments previously made and novel arguments the state could have raised at an earlier stage in the proceeding. Just because you didn't argue it earlier doesn't mean that you couldn't have. So, Corey Richins doesn't go to trial till May. So we've got some hearings before then, though. There's a hearing in November that we're going to cover. And then it goes on to cite the law that a district court does not abuse its discretion in denying a motion for reconsideration that was merely a restatement of the arguments a party had previously advanced. Gee. Could anything ever be more directly on point? Jolly John asked, did we review Spiro's response? We did. It was actually a little snarky, a little restrained. But we did review Spyro's response. And yes, we did review Spyro's response. Let's see. So, isn't that directly on point? A court does not abuse its discretion in denying a motion for reconsideration that was merely a restatement of the arguments already advanced. Further, to extend plaintiff's motion for reconsideration raised new matters that could have been raised during earlier briefing but were not. Such failure would provide a basis to affirm the district court's denial. Some of this is coming from civil law because this doesn't happen in criminal. Here, the state's amended motion both restates primarily factual arguments previously advanced by the state and raises new legal arguments that could have been raised during earlier briefing or at the July 12th hearing. The state, it is my opinion. This is my speculation. The state did not appreciate the seriousness of the situation and continues to misread the situation. The state thought that this was not a big deal and didn't spend much thought on organizing arguments, on writing a written motion, and I think was like, oh, the judge is going to look at this and be like, the defense is throwing up against the wall. When they came into court on the third day of the Baldwin case, I thought the same thing, not having all the information that Carrie Morrissey had. Carrie had a lot of information that we did not have. And I think Carrie looked at that information by the same lens that she has been and went, this isn't relevant. This isn't a big deal. So she did not collect all of the arguments that maybe should have been made out of hubris. Hello, chat. I got completely yeeted because my streaming software crashed. We are working on alternatives. We do not have those alternatives yet. At least it didn't happen during trial. I personally blame Carrie Morrissey. I have now just been victimized by Carrie. I'm teasing, chat. Streaming is dynamic, and I will look as soon as I can move. I will be moving. We are professionals. Streaming is dynamic. Carrie didn't want to hear about the hubris. And I didn't get kicked off line because I was able to tell you in the chat that I would be right back, which is unique when something crashes. So at this point, we were talking about Carrie Morrissey's hubris, but I think she did not read the situation correctly and assumed that the court was going to be like, yeah, whatever. This was not a yeah, whatever situation. I also think that Carrie did not ever see the rounds because I think Carrie was like, it doesn't matter. We can't prove where they're from. I think she believed the way she saw it, that she couldn't see around it. Prosecutors have to be able to see all sides of a thing. It is not always easy, but like you have to be able to see worst case scenario. What is this? And I don't think she saw the rounds. I don't believe she lied to the court about that. I don't think she ever saw those rounds that Troy Teskey brought in. I think she did rely on the assumption that they were the same as the ones in the photo. That assumption bit her in the ass. And that is on her. And she did not appreciate all of this circumstance. But her failure to apprise the situation correctly does not mean that she gets a second shot at it. Look, the defendant, once their case is dismissed with prejudice, has the right to rely on that. No matter what you think of Baldwin or what he did, any defendant has that right, and you should be able to rely on it. So I think Carrie read the situation very badly. I think she just read the entire thing wrong. And that's why we're here. So that's, I think, why she got yeeted. So let me take a look real quick as we're keeping an eye on all of the things that are happening in the world today. All right, let's get back into this. So it goes here, the state's motion, the court continues, the state's amended motion both restates primarily factual arguments and raises legal arguments that could have been raised at the time. Notably, after Baldwin's counsel alerted the court to their intention to file a motion to dismiss concerning the state's withholding of information concerning the ammo supplied by Mr. Teskey, Prosecutor Morrissey stated, "I don't think I'm going to have much of a response. I can probably just do it orally because I've now figured out what we're dealing with." Ma'am, you ran that situation incorrectly. Incorrectly. That is the assumption that got her. You read the room wrong. Right? B2 read the room right. Thank you for the gift of memberships, B2. I appreciate you. And B2 is like, these are the gift of memberships for the ride or dies. The ones that are not just here when it's live trial, the ones that are here after the live trial. So thank you so much, B2. And thank you to everybody that gives memberships, that has joined, and to all our members. It's what allows us to do what we're doing when we don't monetize trial streams through like YouTube ad revenue and what have you. So thank you. Thank you very much. It goes on. I don't think I'm going to have much of a response. I should have just kept reading. Emily, keep reading. Keep reading. Carrie says it. Emily goes on a 5-minute soliloquy about what's in the motion from the freaking transcript. Naturally. I can probably just do it orally because I've now figured out what we're dealing with. Somebody save that line for me later. That's going to end up in a spicy novel. In addition, at the conclusion of the evidentiary hearing concerning Mr. Baldwin's expedited motion for dismissal and sanctions, under Brady, the court offered 15 minutes for the parties to make argument. However, the state elected not to make any argument following the introduction of evidence during the hearing and chose not to ask the court to recess the hearing to allow additional time for the state to conduct research and prepare for argument. Hubris. Determining that the state failed to preserve an argument under case law by failing to fairly invoke the issue before the court. The smackdown. This is the court being like, well, Carrie, if you had done your job, then we wouldn't have a problem here. Do your job. Hold on, my phone. Am I not on do not? Oh, I'm not all the way on do not disturb. My kiddo's homesick. I just got like 4 texts from the school being like, your child has been marked absent. Yes, we sent a note. We know our child is marked absent. We know he is a complete bucket of snot. We are aware. It goes on to say, because the state's amended motion raises arguments previously made and arguments that the state elected not to raise, the court does not find the amended motion well taken. The court's like, no. The state's amended motion is untimely. Oh, the court's not just going to stop there. The court's not done yet. The state's amended motion is untimely. A motion to reconsider filed within the permissible appeal period suspends the finality of an appeal order or judgment and tolls the time to appeal until district court has ruled on the motion. Pursuant to New Mexico NMSA, I forget what the SA stands for, 1798 statutes amended, I think, statutes amended. The permissible time period for the state to initiate an appeal from an order of dismissal by the district court is within 30 days from entry of said order. So there is a way to do it. The court can even with prejudice? I guess so. So under the statute 3933, you have 30 days. Well, Carrie should have known that. It's just so rare that prosecutors get to appeal anything because, constitutional rights. In any criminal proceeding in district court, an appeal may be taken by the state to the Supreme Court or Court of Appeals, as appellate jurisdiction may be vested by law in those court within 30 days from a decision, judgment, or order dismissing a complaint. So there's the law on it. Indictment or information as to any one or more counts, a notice of appeal shall be filed for all other appeals within 30 days. Here, the state filed its amended motion on September 5th concerning the court's July 31st order granting defendant Baldwin's expedited motion for dismissal. However, the state's permissible time period for initiating appeal ended August 30th. Yeet. Thus, because the state's amended motion was filed outside the time limit for the state to initiate appeal, the amended motion is untimely. Therefore, the court does not find the amended motion well taken due to its untimeliness. Does not find it well taken as strong judicial language for what the fuck were you thinking? Although the state filed a 52-page motion to reconsider with prejudice on August 30th, oh, there it is. I was going to go pull it up and see if she filed it on the last day. Carrie filed it on the last day, and the court didn't accept it because it was over page limits. So when Carrie, this is the tea, when Carrie filed it on the 30th, she thought it would just be fine. And the court's like, no, I did not give you permission to file more pages. Like, you don't have approval. You can't just force 52 pages on the court when the page limit is 10. So Carrie files this 52-page motion without approval from the court to file an extended motion. On the last day of the deadline, the court denied that motion because it was beyond page limits. So there was no time. There was no time for her to fix it because she filed it at the last second. It says a brief or memorandum shall not exceed 10 pages, not including the cover page, conclusion, certificate of service, and exhibits, without an order of the court. She asked for an order, and the court did not give her one. The court denied her order. So yeah, the page limit was 10. She filed 52 pages of written motion and hundreds, like 300 and something pages of exhibits. Further, the state failed to obtain an order from the court before filing its motion in excess of the page limits, despite being aware of the local rule and seeking prior enforcement thereof against the defense. Rules for the defense, not for her. Oops. If the court believes the rules should be followed, the state requests the court provide guidance to the parties with regard to the never-ending flouting of local rules. The court is citing Carrie Snark back to fucking Carrie. What? The court's like, remember what you said, girl? Girl, remember? Remember what you said? Yeah, look, remember what you said, though? Oh, quote, it's worth noting that today defendant filed 2 replies that vastly exceed the page limit established by LR 1-305A without waiting for the court's approval on defendant's motion to exceed the page limit. So this was Carrie saying, Your Honor, Why are they being allowed to file these motions that are so long? I'm trying to find where this footnote is coming from, but this freaking copy is so bad. Oh, there it is. This footnote's up here. Although the state filed a 52-page motion to reconsider the dismissal with prejudice on August 30th, the state's motion exceeded the page limits. Footnote 1. Footnote 1. The state's argument that at a minimum, the court is required to consider 10 pages of the 52-page motion that was filed on August 30th, 2024 is unsupported by the non-precedental decisions in which the site states. Oh, Carrie, you're going to get smacked down twice. First of all, the court said it's unsupported by the decisions the state cites. So first, you've cited law that doesn't even apply. It's like, how does this help you? Second, they're non-precedental. So second, it's like, and your authority is not binding on me. First, you cited it wrong. Then you cited something that doesn't even matter. So the court took the opportunity to be like, nah. Oh, the court is done. Oh, the gold is always in the footnotes. The court just took a moment to be like, cute, but no. Let's see. The court goes on to say, compare reply 10 with Tellus v. Tellus. Non-precedental, State v. Rodriguez, non-precedental. The court's like, no. And then goes on to say, further, even if the court were to consider the first 10 pages of the state's August 30th motion, which such approach is similar to that adopted by the New Mexico Court of Appeals in Tellus, the court would have to guess at the state's legal argument. Oh, shit. The court would have to guess at the state's legal arguments, given that the state dedicated nearly all of the initial 10 pages of the motion to a recitation of a factual narrative. And then the court cites law to say no again. We will not review unclear arguments or guess at what his arguments might be. Just start replying to emails with this. We will not review unclear requests or guess at what those requests might be. Please try again. The court's like, no, we're not guessing at what you meant to say. Oh, that footnote. Oh, Carrie. The court is mad. The court is mad. Recitation of a factual narrative. Notice she didn't say recitation of the facts. The court said factual narrative, indicating that she does not see it the way that Carrie sees it, or at least that's what it says to me. Lots of judicial snark, and then citing back to Carrie being snarky about the defense going over page lines is just magic. Ultimately, the court denied the state's motion to exceed page limits via its September 5th order denying state's motion for extension of page limits. Because the court denied the state's extension for page limits to the state's motion, the court does not consider the August 30th motion to reconsider. Due to its non-compliance, the court will not modify the court's order. Grounds warranting a motion to reconsider include 1. Oh, look, there's law. Carrie never cited the law. We finally got into some fucking law. You just need to state what the rule is. What is the rule? We've got to wait for the order to figure it out. Lord. Grounds warranting a motion to reconsider include an intervening change in the controlling law, new evidence previously unavailable, and the need to correct clear error or prevent manifest injustice. Thus, a motion for reconsideration is appropriate where the court has misplaced or misapprehended the facts, a party's position, or the controlling law. Considering the arguments of the state set forth and the in the amended motion or reply, the court concludes the state does not raise any factual or legal arguments that would justify the grant of a motion to reconsider. Therefore, the motion is not well taken and should be denied. I don't know if a court has said get the fuck out more strongly. Like, get the fuck out. Just get the fuck out. Deborah said, sorry to ask, why are you spending so much time on old news? I don't consider it old because I haven't covered it yet. This just dropped while I was in trial. So this is from October 24th and it is the 29th. So forgive me the 5 days it took me to cover this because we were covering trial, but this is not old news. This is, to me, 5 days is within the realm of new, and we had not covered it yet together. So I thought we needed to close the loop for me on the court saying to Carrie, girl, bye, because we had not covered that loop of the court saying to Carrie, girl, bye. So if you mean the Baldwin dismissal, yeah, the Baldwin dismissal had been ongoing, but this was not over until the court said it was over. And now the court said it's over, and now we're done. The court literally, girl, bye, we're done. If Carrie tries to take this to the Court of Appeal, they're going to just kick it out. But we needed to close the loop. We needed the court's ruling. I was waiting for a hearing. I'm bummed we didn't get one. Here's what I'm also disappointed with a little bit. I wanted the court to assign the cost of defending this motion to Carrie. That's what I wanted. I really wanted to see the court grant the defense request that Carrie cover the cost of the motions. Really did. But seeing the court say get the fuck out in like 6 different ways, I thought was magic. So here we go. We, I think, are finally done. We are finally done. So let us wait. We need lip gloss to wrap. Hold on. This one's from Judge Abby. Let's do this. This. I decided that, as much as I try to branch out in the colorways of lippy, like a raisin, like a purpley raisin color is really kind of what's best in my world. And we just, need to go back to the colors I was wearing in college. The black honey from Clinique and all of the different derivations thereof. Okay, let us close it out, shall we? Shall we close it? Let's do it. Are we finally done with the Alec Baldwin criminal rust prosecution? The court in 6 pages told Carrie Morrissey no about 7 different ways, and I think really just said GFO, because not only did the court quote back Carrie Morrissey's words to her, the court actually cited the law that would allow the court to consider this motion to dismiss, the motion to reconsider the dismissal with prejudice that Carrie never cited, but also pointed out that the motion was untimely. Why? Because instead of filing a 10-page motion, Carrie Morrissey filed a 52-page written motion with 300 pages of exhibits without express leave from the court to go over page limits. And she did it on the last day of the 30-day time period. And the court said, I am not considering the 52-page motion, and the amended motion filed September 5th is too late. The deadline was August 30th. You didn't get leave from the court. You didn't file it to the deadline. Untimely. It's untimely. Not only is it untimely, it's not well taken because you could have made those arguments and there is nothing new here. Also, I could have considered the first 10 pages of the 52-page motion, but they were wasted with a recitation of what the court called a factual narrative. Not a recitation of the facts, a factual narrative. So the court has closed this chapter by denying the motion to reconsider the dismissal with prejudice. Baldwin cannot be retried here. Do I know if that will stop Carrie Morrissey from trying to appeal this? I don't think it's going to go well if she does. It might not stop her from trying, though, but this should be done. And if she continues to go, at some point, the courts might assign the cost of these motions to her. It was not a well-taken motion. And the court even cited, which I thought was just the shade on the top of all of this, the court cited what Carrie Morrissey said in court when not raising the arguments that were raised in the motion. The court quoted Carrie Morrissey as saying, I don't think I'm going to have much of a response. I can probably just do it orally because I've now figured out what we're dealing with. I don't think Carrie Morrissey ever really appreciated what she was dealing with these motions. And the court pointed out her failure to raise those arguments in court is her own fault. It is not because they weren't available to her. She just didn't perceive that they were needed. And that is not grounds for this dismissal with prejudice to be overturned. So for now, and I think for good, this case is closed. Alec Baldwin prosecution in the Rust shooting of Helena Hutchins is done. The civil cases are not. And with that, we are done. We are done. Some of you are asking, does Baldwin still have a reality TV show coming? Yes, he does. And can you imagine the drama? Because they're going to center the whole show around the around this dismissal. Baldwin, his wife, they have given no statements. They have given no statements since this. And they're not going to. They're going to show it all on their reality show. All of it. All of it's going to be on their reality TV show, and it's going to be Hear from the Baldwins for the first time. So that show was filming while he was going to trial. They could have never anticipated this result. And that is exactly what they are going to sell for this reality TV show. I can see, like, I can feel the response of like reality TV producers being like, oh my God, we couldn't have scripted this. Nobody would have believed us. If we had scripted this way, it wouldn't have been believed. Like there's no way we could have created this. And here it is. It just fell into our lap. So there's going to be a reality show, and that's where we are going to hear from Baldwin the first time. They announced it. They announced it shortly before the trial, which was wild to me, but they announced it shortly before the trial. So we'll see. I mean, we'll see. We'll see. Let's see. All right. We need to move on to Adelson because there's a lot going on with Donna Adelson. So let me pull up those motions and we will zoom into that. I'm going to make sure that let's see. I'm just keeping an eye on other stuff that is happening in the world, but not too much. I'm curious truly about what's going on and if court will resume in the YSL case. So please don't flood chat. We are keeping an eye on it. So thank you. I appreciate it. And we are going to switch over to talk about Donna Adelson. For those of you not familiar with the case, I'm going to do a brief summary because we're going to get summaries in some of these motions. And I think the summaries in the motions are probably going to be all that we need. But let me make sure I have everything pulled up because there's a new search warrant as well that we're going to go over. And then we're going to go over her losing even more lawyers. So that is, that's going to be spicy. So let me pull up the latest search warrant because that's going to have a really good summary. All right, let's go to the Adelson case. I'm going to use this search warrant as most of our summary because it will, I think, be illuminating. Oh, come on, documents, pull up. I was just like, pull up. Where are you? Oh, you know, when you have to change your whole way of streaming so shit doesn't crash, it can be spicy. All right, let's talk Adelson, shall we? For those of you that have been following this case, I've done a couple podcast episodes on it. We've covered it a little bit here. It was supposed to start trial in September. The day that they had assembled for trial, Donna's lawyers got disqualified by the court. Now, Donna Adelson is the latest defendant to be tried in this. The state is alleging, as to Donna, a murder for hire, conspiracy to commit murder, the murder of her son-in-law, her daughter's husband, at the time ex-husband, father of her grandchildren. Donna's son, Charlie Adelson, has already been convicted, but is appealing and has some really interesting appellate arguments with regard to attorney conflict. Charlie Adelson went to trial first. The gunman and the middleman went to trial first. So the three that were immediately involved went to trial first and were convicted. One of them pled. So 2 trials, 1 plea. Then Charlie went to trial. And after the trial was on the recorded jail call with Donna, his mother, and Donna was talking about her plans to flee the country. And like, maybe we'll get out, maybe we won't. And law enforcement was like, well, thank you for saying that on a monitored recorded line. We'll just go snap you up at Miami International Airport before you get out of the country. And Donna was like, what is this about? Girl, you know what this is about. Because you're on the jail call saying maybe it'll work, maybe it won't. But she was telling Charlie that she was talking to attorney Rashbaum about her fleeing. Rashbaum represented Charlie Adelson at the trial and then was going to represent Donna. And what we learned is that Charlie never really signed a conflict waiver with these attorneys representing his mom. What we also learned in all of this, and it's going to come up more today, is that Donna Adelson, and I covered this in quick bits last week, when Charlie Adelson made his appeal, now that he has appellate counsel, when Charlie Adelson made his appeal, his argument was that he did not ever waive the conflict with attorney Rashbaum representing his mom because Rashbaum represented Donna first, which I did not know until I saw that. I was completely unaware that Donna hired Rashbaum early on in the investigation when she thought she might be implicated in this before they represented Charlie at trial. That might create an issue and an unwaivable issue where Charlie should have gone forward. The appeal from Charlie's lawyers say that he never waived on the record the conflict with his lawyers who had previously been hired by Donna, who was a witness in this case. And the defenses might have been from Charlie, she did it, and from Donna, he did it. But you can't do that if your lawyer represents both clients because they owe a duty to both. I don't know if that's a waivable conflict. I don't know if the state knew that Donna had hired these attorneys early on in the investigation. I don't think the judge knew. So Charlie's arguing now for a new trial due to that conflict, and that's going to be a big issue. So Donna gets to trial and is boo-hooing in court that she doesn't get the lawyer that she wants. Well, Charlie should have had a new lawyer then. Did Donna want Charlie to have the lawyer that she had out of her best interest? If so, that's completely shady. I have so many questions. And Rashbaum should have made it clear if he had been hired by Donna. Now, we haven't seen the response to that. We've only seen Charlie's new lawyers making that filing. But I don't think Charlie's new lawyers are saying there was never a conflict waiver on the record if there was one. That would be really easy to determine. And I don't think new counsel would misrepresent something was not done on the record. That's really unlikely to me. But did Donna actually hire Rashbaum? Rashbaum's going to have to come in at some point and be asked about some of this. It's wild. So the day of trial, the lawyers are yeeted off of the case for conflict. New lawyers are allowed to stay on, and they have also now been yeeted. And we're going to go through the court's finding on that, kicking off all of the lawyers on this case. So the new lawyers that took over are no longer the lawyers. Donna is set for hearing at the beginning of December. When is Donna go to trial again? No idea. This is set for status conference at the beginning of December. It's October 29th? She got new lawyers less than a week ago. So we will see what happens. But we did see, and I covered it, I think I covered it on stream I'm pretty sure I covered it on stream. We did see the prosecutor in the area saying they would be amenable to having conversations about a plea deal. So maybe this will change. And maybe it won't. So for the more fulsome, in the words of my friend Hogue, in the more fulsome, all right. Sorry. Thank you, Miguelina. That sounds good. Instead of me trying to type, we're gonna go through the new search warrant and then all the rest of these. But I saw a really good question from Tori in the chat. Why isn't the issue waived? Wouldn't Charlie already knew or have known his attorney represented his mom first? Charlie might have known, but without a conflict-free attorney to explain to him what the potential issues were and not waiving it on the record, it is a problem. Nicole said, if Charlie does get a new trial, do you think they would try him and Donna together? I think it would be good for them to try him and Donna together because it cuts out the empty chair defense. Like some other dude did it. Like this guy did it. And I saw somebody in the chat mention that they missed my old reading glasses. I do too. I lost them. The ones with the gold. I think I might order a new pair. But when you have prescriptions and custom tints, glasses end up being much more expensive because of all the lens situation. But I am very tempted to order a new pair. But yes, I missed them too. I lost them. They're somewhere in Boston, I think. Or they fell. I don't know. I have no idea where they are. I came home from a trip and I had the glasses case and I opened it up and it was empty. And I went, fuck. No glasses. But the empty chair defense is this other person did the most of the things. Let's go through this new search warrant. This was filed, let's see. This was filed on, where's the court stamp? Oh, that's hard to see. This was filed early October. So this is a new search warrant, but it's going to have a really thorough, September 30th. So filed with the court October 1st. It should have a really thorough breakdown, or it does have a really thorough breakdown of the case. I did not redact out the email address they're looking for. I'm just going to zoom through the first page. They're looking for a Gmail account of Charlie's. That might be listed in here. These are public documents. I imagine that he's not making much use of that email address while in prison, but we'll see. So I am just going to zoom past the first pages so you're not going to see the court stamp because of that. All right, let's do it this way. Your affiant, Investigator Jason Newland of the Office of the State Attorney. Your affiant has been an investigator with the Office of the State Attorney for 14 and a half years. For 21 years has been sworn law enforcement in Florida. On July 18th, 2014 at 11:02 a.m., a report of a shooting was received at the home of Florida State University law professor Dan Markell, and then the address in the city of Tallahassee, Florida. Upon arrival, Tallahassee PD found the homeowner, Dan Markell, slumped over in the driver's seat of his vehicle from an apparent gunshot wound to the head. He was transported from the scene to local hospital, later succumbed to his injuries sustained from the shooting. During the investigation of the homicide, the constant element is that Markell was deliberately targeted. There is no indication this incident was in any way part of another criminal intent to include burglary, robbery. Initial investigation at the scene revealed that a neighbor heard the gunshot and looked out the window where a small silver and light green vehicle was observed backing out of the victim's driveway. During the on-scene investigation of the incident, it was determined that he was the divorced father of 2 small children. The children were not present at the shooting, and their location was confirmed to be daycare at a locally licensed facility. The ex-wife was identified as Wendy Adelson. Adelson was located at a local restaurant and contacted by investigators, was escorted to Tallahassee PD and informed of the situation. She was cooperative during her interview and confirmed that the victim, Markell, was her ex-husband with whom she shared custody of the children. During her interview, she made statements that suggested the death could have been arranged by a friend or family member on her behalf. This is her initial police interview. Her initial police interview involved, somebody might have thought that would be helpful. Wendy, what? For those of you that have been following this case forever, I know you know. But Wendy, what? For those of you new to this case, just Wendy, what? Well, somebody might have just done it on my behalf. Adelson furthered in her suggestion that someone could have arranged the murder to help her and included a statement advising her brother, Charlie, had mentioned hiring a hitman to kill Markel in the past. She and her brother not get along? Cause what? Wendy, what? Is Wendy setting up her brother? Like, I don't understand any of this. Like, this is not self-snitching. This is snitching on everybody else. This is snitching on the rest of the family. She's not implicating herself. She's like, I mean, I don't know. Maybe they thought it would help in my custody fight if they just took him out. Like, family law is so contentious. I don't know how people do it. Family law is so incredibly contentious. It can be incredibly dangerous. We've covered a few of those types of cases lightly. This is not the option because this only results in trauma for the children. Like, everybody's mad about fighting for the kids. This just results in trauma for the children. Everybody's like, for the kids, for the kids, for the kids. You know what? For the kids, this is me preaching. It's not always easy. It's expensive, but therapy, what everyone needs is some therapy to deal with this, not taking someone out. That is not the option. Therapy. This family had the money to handle it. Go to therapy. Don't hire a hitman. Handle your shit like adults. What is this? This is not good for the children. That their entire extended family is going to be in prison for murdering their father. Like, how is that healthy for them? Also, we should talk about the fact that therapy should be more readily available for everyone. But I could rant, and I will stop. Y'all, I don't need to preach to you. Y'all know that mental health is absolutely at a crisis and should be affordable for everyone. But we'll get there another day. Let us continue on. These folks had all the opportunity to pick something else and didn't. Therapy probably would have been cheaper than the hitman, honestly. Adelson furthered in her suggestion that someone could have arranged the murder to help her and included a statement advising her brother Charlie had mentioned hiring a hitman. Look, y'all, I know sometimes it's funny to make these texts to your friend. Like, look, when your phones are downloaded, nobody understands the tone that you and your bestie might be joking. So I'm just saying, if you need to make those jokes with your bestie, A, make sure that you say to the fine person monitoring your phone, I am joking. And B, maybe just use code. Start texting about black-eyed peas. Don't text about a hitman. Text like the feds are watching, not legal advice, life advice. If you don't get the black-eyed peas joke, those of you that get it, and I'm not going to explain it. All right. Wendy Adelson stated that after her divorce, she wanted to relocate to South Florida with her children and felt her former in-laws would suspect her of this crime against their son. Since she was denied the ability to move with her children by the court. So thank you, chat, for saying they tasted all right to me. For those of you that have never listened to Goodbye Earl, now is the time to listen to Goodbye Earl by the Chicks. So it's on the top of the list of songs about murder that I enjoy. So, you know, a lot of you get it. A lot of you in the chat are like, yep. So the circumstance surrounding this homicide is that there had been court proceedings where Wendy wanted to move the children to the other end of the state. As someone who hailed from a large state, I understand how devastating this could be. It's my understanding that Tallahassee and Miami are like not even in the same time zone. I'm being hyperbolic, but are on completely opposite ends of the state. Look, I grew up in California. Opposite ends of the state is no fucking joke. So not moving the children a couple towns away, moving the children hours and hours away from their father. I'm not surprised that the family law courts were like, hey, you can't split custody between Tallahassee and Miami. Those are completely different ends of the state of Florida. So that's not going to work. So the court had denied the request to move to Florida or move to South Florida, closer to Wendy's family, Donna, Charlie, and the rest of it. Interviews with other associates of the Markells and Adelsons, as well as persons knowledgeable in the divorce rulings, indicated that Wendy attempted to relocate the children to South Florida. The court denied the request, and Wendy was reportedly devastated by this ruling. Other statements made by associates indicate that Adelson was not happy in Tallahassee and wanted to move back where her parents live in Coral Springs, Florida. I don't know how close that is to Miami, but I know roughly where Miami is, and that's what we're going with. Close enough. Adelson's parents, Donna and Harvey, made contact with an investigator at Markell's memorial service on Sunday, July 20th, 2014 in Tallahassee. They agreed to contact the lead investigator before returning to their home for the purpose of an interview. The following day, Wendy's attorney informed the lead investigator that Adelson left town with her children and parents to Coral Springs. So he dies, they go to the funeral, and then they all move to South Florida, which is what they wanted in the first place. The attorney could not provide a date for their return to Tallahassee for Donna and Harvey, and they left town before speaking to Tallahassee investigators. They did not notify the investigator prior to the departure. I'm not surprised by that. Donna there were lawyers already involved, and they're like, no, we're not talking to anybody about anything. They have the right to do that. In July 2014, investigators obtained email records from Wendy Adelson. In reviewing the emails, it was apparent that Donna was heavily involved in the divorce proceedings. I am so shocked. This is my shocked face. Donna would email Wendy from the email address donnaharvey@gmail. It was also apparent that Donna and Wendy communicated through email regularly. The emails were similar to cellular text communications in the regularity and content. Over the next year, investigative efforts developed intelligence that indicated two persons of interest traveled from South Florida to Tallahassee on July 16th and returned to South Florida immediately after the murder on July 18th. Those two persons have had contact by phone with a third suspect, Catherine Mangbuana. I think I always pronounce that wrong. My apologies. Catherine was the middleman. One being in contact before and one in contact after the homicide. Catherine had frequent phone contact with Charlie Adelson, Wendy's brother, as well as at least one phone contact with Wendy's father, Harvey. In addition, available records show one of the persons who traveled to Tallahassee had at least one phone contact with Harvey on July 1st. On April 19th, by the way, Harvey has not been arrested at this point at all. On April 19th, 2016, investigators conducted an undercover operation, which had an undercover officer make contact with Donna outside the school of her grandchildren. A flurry of phone calls occurred over the next several hours to include calls between Donna and Charlie and Catherine. So this doesn't surprise me if they had a wire that they will kind of poke the bear, shake the hornet's nest a little bit to try and see if people will talk. So they made contact and did something to rattle the hornet's nest and then see if everybody's going to talk about it because they had a wiretap so they can hear what everybody's saying. You kind of just like, let's see what happens if we insinuate that we know some shit. Let's just drop little breadcrumbs and see if everybody starts talking, trying to figure out what is known, who talked, whatever. People can't keep silent. The more people involved, the more people to talk. So they They poked at it a little bit, and then there was a flurry of phone activity. Over the next several weeks, communication was monitored on the phones of Charlie, Donna, and Catherine. Records show contact communication between Catherine and Charlie, but also constant communication between Donna and Charlie. Emails were not monitored at the time. In October 2019, Garcia was tried and convicted. That's one of the gunmen. He was sentenced to life in prison. In April 2022, after the clarified audio recording from Dolce Vita, a restaurant, revealed Charlie making additional incriminating statements, he was arrested for the first-degree murder, solicitation to commit first-degree murder, and conspiracy to commit first-degree murder. In May 2022, Catherine was tried and convicted. She was sentenced to life in prison. In October and November 22, the proffers were conducted with Catherine confirming many of the investigation's discoveries. Yeah, because by this point, Catherine's like, I got life in jail. Y'all coming with me. Y'all coming with me. So, there's plenty of room for everybody. Shocking. Not my shocked face. In October 2023, trial for Charlie Adelson commenced. November 6th, he was found guilty on all charges. He was sentenced to life in December 2023. In Adelson's trial, Catherine testified that Charlie told her that his mother, Donna Sue Adelson, had just departed his residence at the time Catherine arrived on the night of the homicide. Why does the font change size? Is that me? Or do you all see it too? Sometimes I can't tell if it's me being neurospicy, but it looks like the font changes size and I hate it. Catherine said the money she had received appeared to have been washed. Donna Sue, that is not how money laundering works. Ma'am, I think she literally tried to launder cash. Like, by actually washing it with water. She doesn't even watch crime shows. Ma'am, have you read a book? What are you doing? Catherine said the money she received appeared to have been washed. She also said Charlie told her his mother washed the money at their condo. That is not what money laundering means, Donna. But also, damn, that is. Tell me you don't crime. That is not how money laundering works. The statement was made prior to July 18th, 2014, and Catherine recalled it being stated again on July 18th, the date she received the money. So Catherine, who is the middleman, middle person, is being told the money's been laundered, so it's like not traceable, but actually the money was just like hand washed. I don't know. Did she use a fabric softener? What the fuck? So she did not launder the money to make it untraceable. She actually just washed it and gave wet cash to the middleman. Jail calls from after Charlie Adelson's guilty verdict included multiple calls to Donna's cell phone, in which Donna Sue Adelson is telling Charlie that she is getting things in order, creating trust, and making sure her grandchildren are taken care of. Maybe don't arrange to have their father murdered. Allegedly. In a separate call, Donna discusses plans to take herself out, but also discusses plans to flee to a non-extradition country. We listened to some of those jail calls in an episode of The Emily Show that's on the channel, though I think we have a playlist. I'm pretty sure we do. On November 7th at 11:30 p.m., Donna and Harvey booked flights to Vietnam with a stop in Dubai. The flight departs from Miami on November 13th at 8:10 p.m. to Dubai, and then from Dubai to Saigon. There were no return flights booked. Vietnam is currently a country with no extradition treaty with the United States. She talked about all of this on a recorded jail call. On Monday, November 13th, a friend of Charlie Adelson's contacted the state's attorney's office. They advised Donna, and Harvey contacted them Sunday, November 12th, regarding travel to the Philippines. Donna and Harvey were suspects. I don't know if Harvey was. Donna definitely was. They were not arrested yet. They could leave if they wanted to. So they were not restricted from leaving. The Adelsons advised they had travel plans to Saigon until November 20th, but no further plans at the time. The Adelsons were seeking advice for airlines as well as places to stay. The family friend has known the Adelsons for 10 years and has never had longer than a 5-minute conversation with Donna or Harvey. They found the contact very strange. So even their friends, they're like, hey, we're leaving the country. And their friends are like, bitch, why are you calling me? And then called the cops. Your son just got convicted. Why are you leaving to Saigon? It's not the time for vacation. The Adelsons were seeking advice for airlines and places to stay. The family friend has known the Adelsons for 10 years and has never had longer than a 5-minute combo. They found the contact very odd. Harvey Adelson told the subject, you must not mention to Charlie anything about our plans. Yeah, well then Donna did on a recorded line. On Monday, November 13th at approximately 8 p.m., Donna was taken into custody at Miami-Dade International Airport as she entered the jetway for her flight. Not just in the waiting area. She was going to board the plane because I think they want to use this against her at trial to show that she had intention to flee. Sometimes you can show flight as consciousness of guilt or argue it is connected to consciousness of guilt. I think they wanted to show flight here. So they were waiting until she was like boarding the plane before they were like clink. And then they perp walked her through the airport. She was not thrilled. We watched a lot of that arrest video on stream. So November 13th, 8 p.m., she's arrested as she's getting onto the jetway for her flight, was in possession of a cell phone at the time of the apprehension. They attempted to seize her phone, but Donna attempted to pull it away and prevent him from grabbing it. She said she was not going to give her phone to law enforcement. She tried to give it to her husband. On Tuesday, November 14th, a search warrant was executed at the residence of Harvey and Donna. Donna was in custody at this time. Items seized included 2 Apple iPhones, an Apple iPad, 2 MacBook Pros. I mean, not that they would have been able to delete their phones anyway. They literally washed money with water. A search warrant was issued for all devices. The 2 computers were not compatible with the extraction technology at the time. Therefore, they have not been reviewed. I'm sure at some point they will be. The cell phones collected from Donna as well as the residents have been extracted with reports generated and reviewed. Let's see. In April 2024, a search warrant was served on the email address of Donna Harvey Gmail and Grandma1 Sobe at Gmail. A report was generated for review of Donna Adelson's emails received in April 2024. The state has reviewed Donna Adelson's emails, Wendy Adelson's emails, as well as Celebrate reports of the phones of Donna, Harvey, and Wendy, along with iCloud return from Charlie. Emails have played a critical role in the state's theory of the case. Emails, because it's conspiracy and you need to show them talking to each other or making agreements. Emails between Donna and Charlie were observed in the return from Donna's email search warrant. The emails were not located in any other device or search warrant previously served. So they finally got to some emails between what they are alleging to be co-conspirators, and now they want Charlie's email. Due to Charlie Adelson communicating with Donna via email that had not been previously observed, investigators are requesting a search warrant for Charlie's email to locate any and all communication pertaining to the murder of Dan Markell. The reason they can do this is because they are charged as co-conspirators. But Charlie is now appealing. If he gets a new trial, there might actually be more evidence against him if they get these search warrants back and there's anything there, because they're getting one side of the conversation from Donna's search warrants. The undersigned affiant is an investigator. The basis of the affiant's experience is listed, and then they're asking for a Google search warrant for that other email address from the end of September 2024. So they are still gathering evidence in this case because they are co-conspirators to show the emails back and forth that they came to an agreement, because you have Catherine saying, Charlie approached me to talk about this. You have some conversations with Catherine and Donna, but this might tie in even more. And the more they get to, the more it uncovers. You could still have other arrests here. And I see the comment from Celia in the chat say, I can see them wiping their phones with a microfiber cloth. 10 out of 10. 10 out of 10. 10 out of 10. So with that, Donna has now opened the door to potentially more evidence against her and Charlie. So they're doing an additional search warrant that'll be done before trial, because this search warrant was asked for after the trial got continued. Had the trial not gotten continued, they wouldn't have any of this. And this is a 2014, this murder happened 10 years ago, and they are still uncovering digital evidence. When you give the state more time, often they will use it to their advantage. They're not just going to sit there and wait. So the state is now going after another email address that they did not have a search warrant for. And Donna's lawyers got yeeted. So we're going to go through everything that happened to get the second set of lawyers yeeted. If we ever want to go back through the video of the day that the lawyers got yeeted, let me know. Maybe I'll break it down on a podcast and we can do that. We're not doing that today. We're just going to go through the filings, but we've got a bunch of filings to go through. So let's talk about attorneys getting yeeted off the case. This filing is from October 5th, and it is a notice of appearance of co-counsel. Keep this name in mind. This is a new attorney who is appearing as co-counsel for Robert Alex Morris. Morris had been co-counsel with Rashbaum and had stayed on the case, if my memory serves correctly. It's requested that copies of all pleadings, motions, and notices be supplied to the firm of Commissar Spicola. I'm trying not to say Spicoli because that's not right, but my brain goes to pop culture. At the address shown below, which is the law firm of Commissar Spicola. And so that law firm with Adam Commissar and Commissars from Commissar Spicola is being added. So new attorneys being added on October 5th. So we have a new co-counsel that was added. Then we have notice of case management conference from October 7th. This is a court filing saying, hey, we're going to have a CMC. The above mentioned case is set for 2:30 p.m. Tuesday, December 10th at the courtroom for case management conference to go through everything that needs to happen with this case. So September 5th, new co-counsel. No, October 5th, new co-counsel. October 7th, they set a case management conference with counsel. Then you get the defense asking for clarification. Let's see. On this notice of appearance. Is this the right one? No, that's from the 22nd. Where is it? We have one more motion that I am looking for that didn't save in the right order because we have the defense asking for clarification from the court. And that's what I'm trying to find real quick. And I am not seeing it. Oh, give me 30 seconds and I will grab it because I want to go in order. And somehow that motion for clarification, I downloaded it. It just didn't make it into my drive. Now it's in the drive. So we get the co-counsel added. And then on October 4th, we get this motion for clarification, like the day before that co-counsel is added. This is from Donna's attorneys from October 4th, motion seeking written order and clarification of the court's September 17th ruling. September 17th was when trial was supposed to start, when the other attorneys were yeeted. Comes now defendant Donna Sue Adelson by and through her attorneys. Yay, yay, yay. They file a motion seeking written order and clarification of the September 17th order oral ruling as grounds, therefore would state. That's the worst sentence ever. Maybe I just read it badly. On September 17th, the court granted attorney Rashbaum's request to withdraw. Well, no, the court was going to withdraw Rashbaum. The court was going to yeet him off the case. And then he was like, yeah, I need to go. So it was like you can quit or you can get fired, but either way, you're out. The court granted Rashbaum's request to withdraw and conducted in-camera examination of Rashbaum and remaining counsel Alex Morris. We've been covering too many Alexes that go by Alec and my brain is broken. Alex Morris to determine who could cross-examine Charlie Adelson if called by the state at future trial. After the in-camera examination, the court pronounced, quote, "The court has concluded its in-camera hearing with former counsel and remaining counsel, Mr. Morris. Ms. Adelson, pending if you choose to hire additional counsel or just reset the trial date, you will certainly be able to work with Mr. Morris as your attorney in making that decision, but the trial is going to be continued." Footnote 1. The undersigned has not yet obtained a transcript and would defer to any official transcript. The oral ruling is made available at 5:06:40 on YouTube. Please refer to YouTube for what happened. Oh, this is why cases should be televised. It's like, go to the tape. Mr. Morris is and shall, for now, as of this motion, Mr. Morris is and shall remain lead counsel in accordance with Adelson's wishes. Adam Commissar has been retained by Adelson as co-counsel to Morris. Before proceeding, counsels for the defendant are seeking clarification of the court's ruling regarding Alex Morris's ability to cross-examine Charlie Adelson at a future trial and any limitations that exist on Morris's ability to share information with Commissar as co-counsel or other future co-counsel. The court's offer to Adelson to proceed with Morris as sole counsel appears to reflect a finding that Morris was appropriately walled off from Rashbaum's former client and is free to conduct cross-examination and share information freely with new counsel. Counsel seeks clarification as an officer of the court, seeking to both protect the judicial process and allow for accurate future trial scheduling based on the division of the workload. I think this is appropriate, Your Honor. We need to be clear on what you ruled, what you anticipate, and what you want us to do. Like, what do you want us to do? So with this, they were asking the court for new counsel to come in with Morris. Morris had been co-counsel with Rashbaum, and the court responded and did not clarify their order. Well, maybe the court did clarify their order. Here's what the court did on October 7th, while we were getting ready for other trials. Order disqualifying defense counsel. Excuse me, Your Honor, can you clarify how I handle this trial? And the court was like, yeah, you don't. I've thought about it more, and you're out too. I thought about it more, and you are out as well. So now, co-counsel is also yeeted from the proceedings. Order disqualifying defense counsel. The cause came before the court on its own motion. The court was like, clarification, you say. Let me be perfectly clear. None of you. None of you. The court, having considered the record developed on September 17th, including the positions of each party, the relevant legal authority, and otherwise being fully legally advised, finds as follows. The withdrawal of defense attorney Daniel Rashbaum became necessary when he engaged in a conflicted representation falling short of the ethical obligations for members of the Florida Bar. This is going to be an issue when it comes to Charlie's trial. How that happens, I don't know. But if Rashbaum represented Donna first and then represented Charlie and then didn't tell Charlie, it is a huge fucking problem. And even telling Charlie and not getting a waiver on the record is a huge fucking problem. Katie said, I said good day. The judge probably. What did Judge K say? Counsel. Respectfully. Parent, get the fuck out. Respectfully, counsel, get the fuck out. Upon further consideration of the September 17th record and in-camera proceedings with attorneys Rashbaum and Morris, a sufficient ethical wall was not established. Oh. Footnote 1. On September 20, no, I read that wrong. Let's start again. Footnote 1. Pretend you didn't see that. We're just doodle-doo, doodle-doo. On September 17th, 2024, this court pronounced that the defendant could work with Robert A. Morris in choosing to hire additional counsel or resetting the trial date, as her motion for clarification identifies. However, as this court explains, a review of the written transcript of the proceedings and of the relevant case law has convinced this court that disqualification of Mr. Morris and Adam Commissar are required. Oops. You would like clarification. Both of you get the fuck out. Counsel and new counsel, get the fuck out. Both of you. All of you out. So when they talk about an ethical wall, the ethical wall is that nothing that Rashbaum knew from representing Charlie was conveyed, overlaid, crossed over, anything with Attorney Morris. And the court's like, you didn't do that. And also you brought in new co-counsel, and also they're out. All of you out. Thus, the conflict of interest involving privileged information or communications has been imputed to Morris. Additionally, this case is, quote, rife with potential for the same conflict to Adam Commissar. Unimputing a conflict seems as implausible as unringing a bell, unscrambling an omelet, or pushing toothpaste back into the tube. Whichever judge wrote that, hear me out for a moment. Or putting the shit back in the horse. Putting the shit back in the horse. I'm just saying there is another alternative. There is another alternative. Just making a plea. But the court used all of them as implausible as unringing a bell, unscrambling an omelet, or pushing toothpaste back into the tube. The court went all the way there. The court's had a minute. You think the court's been thinking about this? You think the court's been thinking about this for a minute? Florida rules regulating Florida bar 4-3.5C and 4-8.4D impose on Florida attorneys. This is all attorneys. These are from the model rules. Each state says it a little bit differently, but all of these, this is not substantially different based on jurisdiction. Impose on all Florida attorneys an ethical responsibility to refrain from engaging in conduct intended to disrupt a tribunal and conduct which is prejudicial to the administration of justice, while the defendant retains a presumptive right under the Sixth Amendment to counsel of choice. The right is not absolute. Right, Donna, you can't just have it your way. And Donna, if you hired the lawyers first, you should have kept them. They don't go to your son. They stay with you. He can hire his own lawyers. And his own lawyers might say, hey, Charlie, your best bet is to drop a dime on mommy and tell them everything and try to get a deal for yourself. Like, I think most attorneys would approach it that way if they didn't have a conflict with Donna. But an attorney that's already loyal to Donna is not going to tell Charlie that his best defense is to flip on Donna and to be like, look, my mom wrote me into all of this. Like, I know I'm an adult, but my mom wrote me into all of this. This is hypothetical best argument. And there was no dissuading her. And so I was just in it. That is likely what a defense attorney is going to say. Look, your best defense is to flip on your mother and see how it goes. Also, the court might be amenable to it, but and you might be able to take a plea deal to tell everybody. Maybe not, because the middle person got life in prison, the gunman got life in prison, the other one pled. Maybe not. But if an attorney is loyal to Donna, they're not going to tell Charlie that's his best possible defense, or even possibly discuss it with him. So you can see where the issues are screaming. Pixie Patty said, did his mom hang him out to dry? Yes, he was drier than the money was. Possibly. This is speculative based on all of the things we've seen here. So, Both federal and state courts have repeatedly made clear that the right to counsel cannot be manipulated so as to obstruct the orderly procedure in the courts or to interfere with the fair administration of justice. The Florida Supreme Court holding in Bundy v. State that there is no absolute right to a particular counsel where there is a countervailing public interest in fair and orderly administration of justice. The court goes on to say the fair and orderly administration of justice cannot be maintained when conflicted counsel or counsel with the potential of conflict cannot meet the standard of serving as constitutionally effective counsel. And this is where I think the Charlie Adelson appeal is going to be very interesting and very fact specific, which apparently means SPAC. That's apparently shorthand, not for where you go see concerts, but for fact specific in one word. This is where Charlie's appeal and his appellate counsel saying there was conflict here might land him with a new trial. Like, conflict is one of those things that's real messy. Soul Seeker said, isn't conflict of interest covered in law school and the bar exam? Like, and everything? Yes. And everything, yes. I am probably one of the, I can spot conflict, but in how to deal with conflict, it's not something I had to deal with much because I was a state's attorney for most of my career. So looking for conflict was more like issue spotting, like, hey, Your Honor, I think that might be an issue there. Y'all deal with that. So my overview of conflict is like, you can't do this. But representing two criminal defendants that have potentially opposing defenses is pretty fucking clear. Oh boy, this is a problem. This is a problem. This is a problem. This is going to be a problem on that appeal for Charlie, which now I'm way more interested in because this has gotten into a legal shit show that is fascinating and shocking that we're here. Like, I was stunned. I was in an Uber getting back from being at federal court the day that Diddy was arraigned as all of this was going down in court. And I was like, no way they're disqualifying counsel. Like, no way this is happening right now. I was shocked. So it goes on to say, furthermore, the danger to conflict-free proceedings was not cured by Rashbaum's withdrawal. Prior to the selection of a jury, Charlie Adelson filed a notice indicating his non-waiver of any conflict of interest with Rashbaum. Morris then filed a response in which he advised that third-party counsel had been retained to resolve any actual or potential conflict of interest. In reply to this response, Adelson objected to Morris or third-party counsel cross-examining him. Charlie said, no, my former attorney owes me a duty as a client and he can't cross-examine me. There's no way. The Third District Court of Appeal, when reviewing the disqualification of counsel in Colker, disagreed with the proposition that actual or potential conflict could be avoided by having substitute counsel conduct cross-examination of a former client. So there's a case directly on point. That court found that the conflict arises from the past relationship and cannot be avoided by sectioning off portions of the trial. The potential for conflict would remain, as would the appearance of impropriety. Like, if you guys look at that and just go, that just seems bad. Like, your attorney that you hire to be in your corner is now sitting with the team that's cross-examining you. That appearance is bad enough, but there's an actual conflict there. Absent judicial intervention at this point, delay to the fair and orderly administration of justice will be at risk of repeating itself. Without the establishment of sufficient ethical wall and the fact that even third-party counsel cannot avoid potential for conflict, the court cannot permit Robert Morris or Adam Commissar to remain as counsel of record, nor will the court permit this untenable situation to continue. Damn. The court's like, no. nor will the court permit this untenable situation to continue. Accordingly, for the reasons above, attorneys Morris and Commissar are disqualified from further representation of defendant. The case management conference scheduled for October 15th is canceled and reset for December 10th. Conflict-free counsel for defendant is to file notice of appearance in the interim period. Any transfer of the physical case file by prior counsel is to be done without annotation or oral communications that would create another imputation of conflict. Paper, and that's it. Turn over the files and say nothing. So the court has yeeted everybody. Hey, Dr. B. Hello. The court has yeeted all of the attorneys. The court is just like, we're done. But then the court attached the transcript. Do you guys want to go over the transcript? Do you guys want to go over chat? Do you want to go over the transcript? Do you want to go over the transcript? Shall we? Shall we do that? Shall we do? I feel like we got a little time. They gave us like 40 pages of a transcript. I feel like we just do that. Because I feel like there's probably more tea, right? Chat's like, we roll. Let's go. Let's do that. All right, it's been a minute since we've had a transcript to go over. This is from the day that trial was supposed to start, where Donna was boo-hooing in court. September 17th, commencing at 8:26, concluding at 1:30 p.m. I don't know what is in here. We have not read it yet. So grab your coffee, grab your tea. Let's read a transcript and see what else we see. So all of the attorneys have now been yeeted. So Donna has to find new attorneys. How mad do you think Donna is? I think Donna is pissed. I think Donna is probably pissed that she doesn't have control of this situation. I think she is. I think Donna is big mad. All right, representing the state's attorneys, representing the defendant, Rashbaum and Morris. Also present, other attorneys, including Commissar. So other attorneys in the chat. Not in the chat, in the courtroom. So proceedings, yes, in the chat. They were basically in the audience, so they were in chat. Those attorneys were basically in chat just for the things. Let's see. Thank you, Miguelina. The court. Good morning, everyone can be seated. Good morning, Judge. The court, Ms. Niles, come on up. You can stand at the lectern if you wish. Niles, certainly thank you. For the record, Niles on behalf of the state witness, Charlie Adelson. So this is Charlie's lawyer appearing in court. All other counsel of record can make their appearances at this point. I'm wondering if we should just watch it instead of read it. Maybe. Should we watch it? Should we watch it instead of read it? Have anything that is, if we have anything that's part of, let's see. Let me start a poll. Watch. Shall we watch it? Emily, are we just doing this on the fly? Read it. I want to see if there's anything from, I vote. I'm going to let you guys vote. I'm going to look through and see if there's anything in here that is from SideBar. So let me take this down real quick. I'm going to look and see if there's anything in this transcript that is from the in camera, because that we won't see if we watch it. Let's see. This says oath administered. Let me see if this happens at SideBar, if this happens in court. If these happen, if these are the recordings of the in camera, then I will go through those separately. But let's watch what happened in court, and then I will look for whether or not this happened in camera and go through that. So let's watch it, and then we'll read in the SideBar conferences, because there are sidebars here, and we'll go back and forth between the two. Oh, let's see if the sidebars are included. It says sidebar conference concluded, but I don't know if that's reported. Oath administered. Let's see. I'm just perusing this real quick. Sidebar conference conducted. Yeah, the sidebars aren't in here. It just says sidebar conducted. It doesn't actually have the transcription of it. So we're not going to learn much new that we can't learn by watching this, except, let's see, except for this notice. We're going to go through this notice first, and then we'll go to the hearing that day. Most of it we're going to zoom through. But we'll go to this notice that was filed. We haven't covered this either. This is what prompted all of this. So let's swoop to this. And then Miguelina, if you'll look for this from the 17th. Thank you. Emily, were you prepared to watch it? Nope. Did we decide on the fly? Yep. Why? Because we love live court. Sixth, state witness Charlie Adelson's noticed that he is invoking his Sixth Amendment rights to his former counsel, Daniel Rashbaum, and he does not waive the conflict of interest regarding his attorney-client communications with Rashbaum. State witness Adelson files the notice that Adelson was previously charged in Leon County with first-degree murder, conspiracy to commit, solicitation. Case went to trial. Adelson was convicted. Adelson was represented by Rashbaum at trial. Adelson's judgment is not final. He is currently pending direct appeal. Adelson is now represented by undersigned counsel. In this case, the state filed an amended answer and demand for discovery on July 11th. The document listed additional prosecution witnesses, one of whom was Mr. Adelson. The state has issued a subpoena for trial for Adelson, and Adelson was transported from prison to the Leon County Jail on September 13th. Undersigned counsel was able to meet with Adelson at the jail on Sunday, September 14th. The trial in Adelson's case is scheduled, in Donna Adelson's case, is scheduled to begin the week of September 16th. Rashbaum is one of the defense attorneys representing Donna. The Sixth Amendment to the United States Constitution states that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. They go on to say the essence of the Sixth Amendment right is the privacy of communication with counsel. The attorney-client privilege is the oldest of the privileges for confidential communication known to common law. It is the purpose to encourage full and frank communication between attorneys and their clients, and thereby promote broader public interest in the observance of law and administration of justice. Then they go through the rules from the Florida Bar, which the judge had summarized. And then they go through the case law that the court had summarized, the Kolker case. Thus, because Mr. Rashbaum previously represented Adelson, Rashbaum previously represented Charlie, currently represents Donna. The state has subpoenaed Charlie as a witness in Donna's trial, signaling its intent to call Adelson as a witness, Charlie. And if Charlie is called as a witness by the state during Donna's trial, then Charlie would be subject to cross-examination by his former attorney, Rashbaum. Charlie files this pleading, invoking his Sixth Amendment rights as to Rashbaum, his former trial counsel. So Charlie blocked Rashbaum from being his mom's attorney. I don't think he's wrong in this. I think Donna was probably pissed. I think this is a gloves are off moment because now Donna has lost all the attorneys that she wanted to represent her. Further, unless there is a finding by the court that Donna's defense team constructed an ethical wall with regard to Rashbaum's knowledge and information gleaned from his prior representation, then his representation of Miss Adelson is in the same or substantially the same matter, then Charlie Adelson would assert privilege to everybody and the entire defense team and ask the entire defense team to be yeeted. So that is the notice that brought up the issue. Again, the court had taken multiple waivers from Donna. You know this person represented your son. Multiple waivers from Donna. What I didn't know at any point was that there were never waivers taken from Charlie. I had no idea. I had no idea. And it is shocking to me that there were never any waivers taken. Like, how do you do that? It's an apparent conflict. When everyone saw Rashbaum showing up in court, it was absolutely wild that she was representing. So, or that Rashbaum was representing Donna after representing Charlie. And then hearing that he represented Charlie first, oh boy. Nope. So let me pull up this court day and see what we can find. It's not helpful if it's just giving me my video. I want that day in court. I just want the full day in court. I just want the day in court. It's going to take me a second to find that, you guys, but I'm sure it is up. I know Megalina was looking for it too. I am looking for the full day in court. Let's see if I can find it on, thank you, Megalina. So let's see if I think, you guys, we are looking for it. Just give me a second. So thank you for hanging. It's going to take me a moment, because I know that this day was streamed. Let's see. I found it, Megalina. I don't know how good the audio is, but I found it. So I'm going to pull it up. Do I know how good the audio is? No. Are we optimistic? Sure. Of course we're optimistic. We love being optimistic. There's going to be a lot of zooming this day, but we're going to hear what the court has to say that day, and then we will do Q&A. But this is going to be a problem. So when will Donna Adelson get to trial? I don't know. Will Charlie Adelson get a new trial? I am often like, I'm not so sure what's going to happen. But on this one, like, it's a maybe. That conflict problems are unwaivable. Like it really might. It really might be that Charlie gets a new trial. He's at trial with Donna together. They all have new attorneys. This is wild. Wicked Blondie said, how uncommon is it for lawyers to be dismissed in reality? Fairly uncommon. Normally attorneys do the conflict check at the beginning. And if there is even a whiff, a LaCroix, a faintest hint, a burp in the general direction of a conflict, they nope out at the beginning. So generally you see this like with, if a public defender has a conflict and then the alternate public defender has a conflict, then you go to panel attorneys and you see if any of the panel attorneys have a conflict. Normally there are very thorough conflict checks at the beginning. And if there is anything that might be a problem, they nope right out. A scintilla, if you will, chat. Yes, a scintilla. A whiff. A LaCroix. Witness said a fart in the general direction. Yes, exactly. A fart in the general direction. From Monty Python. Nightshade Winter said, as a former prosecutor, do you think Charlie deserves a new trial based on the conflict issues? I want to see the response to it. But if the facts are that Donna was working with Rashbaum before Rashbaum represented Charlie, then I think it's going to be a big issue. But I want to see the reply on it. So I want to see the reply on it, but it might be a big problem. And that's unfair to the victim's family. It's unfair to the state. But at the end of this hearing, the judge does charge monetarily some of this delay to the defense. So could there be sanctions here? There could be. I have no idea how this audio is. This feed is the only feed I found, and it does not have closed captioning, but on replay, we will have closed captioning here. And so Tammy asked, and we'll get to this more Q&A, am I following any other live trials? Not at the moment, but we will be. Well, we have more trials coming up on the docket, and I'll be talking. I talked about it a little at the top of the stream, and we'll talk about it a little bit more later about what is on the docket. But at the moment, no, we're going to take a minute. The mods all need a minute. I need a minute. We all need a minute. And it's going to be, there's a lot between like Halloween and Christmas. A lot goes on, but a lot of delays happen in court because everybody's kind of like, and jurors don't want to be there. Jurors are like, So we will see. Yeah. Let's, yeah, Megalina, it is. That's the only feed I found that was still up. So we'll just do our best. Because potato. A blurry potato. All right, let's zoom until we get to the judge being on the bench. And we go from the blurry potato to the not blurry potato. Did I swoop? I hope I swooped. We should go to, look, we're in court's live in the past, but we're watching court. So, you know, I love live court. We've had some hearings we needed to catch up on. So why not?
All right, court is out of session. Judge Stephen Everett.
Potato.
Morning, everyone.
You can actually hear them adjusting the camera. Who is peeking into my office? Dr. B, is that you? What do you need? Hey, T, what's up? I'm streaming. Did you take some Dayquil? How are you feeling? Okay. Did you want to see if I had seen memes that you sent me on Instagram? Oh, we'll do that. We'll do that after I'm done streaming. I appreciate that you want to investigate CD rates. So Travis is sick. But we will talk about that later. He's like, I want to know what the rates are for the CD. You can probably research that on just the internet. Anyway, yes, CD rates. Travis is doing some financial stuff in class and is looking at what he wants to do with some of his savings. So, which I encourage him to learn about because, you know, when I went away to college, I didn't know that overdraft was not actually part of money that I had. So we try to help, the kids understand a little bit more about money than I feel like I did. So he is trying to compare whether the high yield savings or a CD might be a better rate. So he's also been doing pretty well with some of his stock investments. All right. The judge is coming out onto the bench. This judge has the most neutral demeanor like ever. Linz, I'll take a look at that. Thank you. So this judge's demeanor is just unfazed. Like even when fuckery is popping off, just so unfazed. Like just calm, keeping everybody calm, just unfazed. I appreciate that. Also potato. It's not you. It's the potato. But I like this judge quite a lot. This camera angle is a tragedy and needs to be addressed.
Miss Dials, come on up. You can stand at the lectern if you wish.
I don't know what, I can't move me. There we go.
On behalf of State Witness Charlie Adelson.
That's a little better.
All other counsel of record can make their appearances at this point.
Georgia Kappelman for the state.
Alex Morris on behalf of Mrs. Adelson.
Dan Rashbaum on behalf of Mrs. Adelson is present.
The lighting in this courtroom, just it from the screen looks like a migraine waiting to happen.
So, how was everyone's evening last night?
Got a lot of sleep, Your Honor. How about you?
Slept like a baby. Let's start with the notice of invoking rights and
Slept like a baby. The judge is like, I'm
Mr. Adelson, do you have anything?
The judge is like, I'm unbothered. How are you? I realized that I was blocking where Donna was sitting in court. I'm unbothered. How are you? They're getting ready to start trial. A jury is supposed to be coming in and they've got a few things to address. So Donna is out of jail clothes, ready for trial. So they are ready. And the judge is like, another day, another trial.
Thing to argue beyond.
I mean, the
what's in
bailiff's rocking a mug of
Your Honor,
coffee.
I'm not here to advocate for a position for the court to do something in this case. The only thing I intended to do with my filing is to invoke Mr. Adelson's rights, to put the parties in the court on notice that he does intend to invoke his rights.
Right. Ms. Kappelman,
The judge is
does
like,
the state have a position
yeah,
that it wishes
great.
to raise concerning the notice or the filing?
My only position, Judge, is that this issue has been waived. Your Honor did an inquiry, which was thorough, covered the issue, and
As to Mrs. Adelson.
yes, sir.
Not to
concerning
Charlie.
Adelson, I believe.
Not to
Well,
Charlie.
I don't want to get ahead of myself, but the only way
Mm-hmm.
Mr. Rauschbaum's representation could occur is if both ends of the conflict were waiving. I don't believe Mr. Adelson ever took an affirmative position one way or another.
My understanding was he did, but I guess that position is changing, so I don't know, I have to defer to Your Honor on that.
Does the state intend to call Charles Adelson as a part of its case in chief?
No, he would be a rebuttal witness at this point. Now, that could also change too, but as of this moment, he is a rebuttal witness.
Ms. Niles, is
That
there a
could
reason
change.
that your client waited until yesterday to assert
Why did Charlie
his
wait so long?
invocation of this right and non-waiver?
Your Honor, I think the critical question is when the conflict arose. So,
Oh, the conflict has been there. The conflict is clear on its face. It's as clear as my nose. Is there a reason your client...
And this is why I think if Rashbaum did in fact work with Donna first, then there is a problem on appeal. So why did Charlie wait so long? And the attorney's like, well, you know, if he wasn't going to be called as a witness, then it's not a problem. It's like, girl, the judge is like, we're not new here. This conflict is glaring at everyone. I really don't think the judge knew that that Donna hired Rashbaum before Charlie hired Rashbaum. And I wonder if when that appellate filing dropped like a week and a half ago, if the judge was like, are you fucking joking me? Because it's a problem.
did not assert this until yesterday.
Your Honor,
They're going to say we
my
didn't know he was going to be a
understanding is
witness,
that my
right?
client has not waived at any point. And so asserting it
Yikes.
yesterday was merely putting the parties on notice of that non-waiver. I mean,
Which they should know.
The fact that he's listed in discovery as a Category A witness does not mean that the state was going to call him as a witness at trial. I think the conflict arose when my office received a subpoena for his trial testimony, which was last week on September 11th, and then he was transported to the jail on September 13th. Mr. Efferman was able to meet with him at 8 o'clock in the morning
On a Saturday.
the 14th.
Right.
And then at that point, without revealing any confidential communications with our client, we became aware that all the parties needed to be on notice that there was no waiver and that he does intend to invoke his rights. And so our notice was filed the next business day, Monday morning. It was later in the morning, but we were trying to get it done. We were a non-party, so we were having some trouble figuring out how to get it filed, but we drafted it and alerted the parties and the court as soon as we knew that this was an imminent issue, that his rights were imminently potentially going to be violated. Now, I don't think, excuse me, I don't believe they would be violated until he takes the witness stand, and at that point, either his former counsel attempts to cross-examine him, or another member of the defense team attempts to cross-examine him, or they advance an interest that is materially adverse to his
Chat, there are no
interest.
captions. I'm
So,
sorry on this feed. It's the only feed of this
I
hearing
think
that we could
the
find.
potential for conflict was always there, but the conflict arose. It's going to arise on the witness stand. It has not quite yet arisen, but the potential for conflict.
It's simmering, not boiling.
Yes, Your Honor, it's burgeoning.
It's burgeoning.
Mr. Morris.
Burgeoning conflict. So what the attorney for Adelson, Charlie, is saying is, look, until he gets called as a witness, it's a problem, but it's not all the way a problem, because it's not a problem if he doesn't get cross-examined, but if he has to get called as a witness, then it is a problem when you don't know if he's going to get called, so it's potentially a problem.
Judge, when I came into the case, at the inception of the case, obviously I was aware of the fact that Mr. Ashbaum had represented Mr. Adelson. I was aware of the conflict, whether it's arisen or not. My view of it is that it's always been there and been present. As a result of that, I have been walled off from everything as it relates to any discovery from that prior case.
This is Morris, who then got yeeted.
I've not had any conversations with Mr. Ashbaum about Mr. Adelson's evidence or property. The first instance that I met Mr. Adelson was this past weekend on Saturday with Mr. Ufferman. And in fact, Mr. Adelson queried whether or not I had seen his phone. I said, no. But we planned for this exact circumstance. And
Because they knew, because everybody knew.
I was going to conduct any cross-examination if Mr. Adelson were to testify. Mr. Ufferman's motion argues to impute the conflict absent a showing, a good faith showing of an ethical wall. I think that we've done that, but of course, as I mentioned in my response, we plan in the alternative if we're forced in that direction of securing alternate counsel.
When was the third-party counsel retained?
Candidly, there's been no retention in terms of money from Mrs. Adelson to that lawyer.
So third-party counsel's not retained. They're just on standby. So
That's prepared to happen. We wanted to see Your Honor's ruling. But the answer is I spoke with the attorney yesterday to confirm, just as I mentioned in the response, availability and absence of conflict for that lawyer.
All right. I've gone through, I believe, at least 2 Lazarlet inquiries with your client, specifically as to this conflict that exists between his former client, Mr. Adelson, and his current client, Mrs. Adelson. Is there a reason the defense did not bring before the court that you were pursuing third-party counsel, or there was, in fact, no waiver from Charles Adelson?
Well, let me back up and provide the court some information then.
no waiver from Charlie Adelson is kind of the kick in the balls on this, because I think the court was operating under the belief that Charlie had waived. And now counsel for Charlie is coming in here saying, there was never a waiver from Charlie. I think counsel had represented that it was all good, but there was never actually a waiver. They took all the waivers in the world from Donna, but Charlie didn't waive. And that is where this issue is.
And so there was, in fact, a waiver with Mr. Rashbaum. Mr. Rashbaum consulted.
Was there though?
Both. There was a third-party lawyer, Mr. Moses, who was hired as third-party.
Morris, by the way, just said there was a written and verbal waiver from Charlie. I don't think that's 100% the case.
Counsel out of South Florida to consult with Mr. Adelson independently outside of Mr. Rashbaum's presence. And
Rashbaum told them there would be.
My understanding
and there
is that
isn't.
the waiver was agreed to. I believe it's going to be verbal, Judge, in the sense of not in writing. The written portion of it is the lawyer who consulted with Mr. Adelson.
That said, even if there was a waiver, it can be withdrawn. So even if, and I don't think there was, I think this gets worse, but even if there was a waiver, it can be withdrawn.
That was because of security issues. That is the way that that was dealt with. It was post-conviction. The Department of Corrections housed Mr. Adelson closely managed, and as a result, there was an inability to get to him in a face-to-face conversation. So the waiver issue did occur, and then retention of third-party counsel, we had never believed it to be an issue because of the game plan as it relates to me handling cross-examination and being walled off, and not until the issue that Mr. Ufferman raised did we make that move.
Right.
Assume for a moment that I find the walling off has been sufficient. Why should Mr. Rashbaum's representation not be terminated at this point?
The motion that Mr. Ufferman has filed is a conflict as it relates to cross-examination. Mr. Adelson, as I understand it, his objection is not to Mr. Rashbaum's continued representation of Ms. Adelson.
Well, your client has a right to effective representation at every single critical stage.
Right.
I'm also not going to allow any issues basically to get backdoored should there need to be an appeal.
Never came to my mind.
Never came to my mind.
Is there any dispute that Mr. Rashbaum does not
Charlie might
meet
get
the
in a
elements
trial.
of Colker?
I
No.
don't believe so, Judge, no.
Right.
A substantially related representation.
The judge is like, tell me how this is not fucked. And counsel was like, so I can't tell you it's not fucked because it's fucked. They're ready for trial. They've cleared, and for judges to clear their schedule for a trial that's going to be a couple weeks long takes a lot of work. Other cases get bumped. To clear your schedule for a trial like this, spend the money on a trial like this, and then come in and be like, so this thing that was really obvious to everybody is the problem. Oh boy.
And a client that is now asserting a non-waiver of a conflict.
Well, also from a practical perspective, this is, as the court mentioned, this has been a known circumstance from the inception.
Right.
And
It has.
And y'all said it was all
but I
good.
think that cuts both ways in the sense that, and I don't,
What speaks really loudly to me is that it seems to me, and this is my speculation as an outsider, we did not watch Charlie's trial. When Donna got arrested, I was like, bitch, what's up? And then I heard the jail calls. I was like, okay, law nerds had been asking me about Charlie's trial. I'm like, all right, I'm in now. I'm in. But what is clear to me is that the second that Charlie got conflict-free counsel, he went, oh yeah, no, I'm not waiving that. And that's the problem. Charlie always should have had conflict-free counsel. So should Donna. Their representation should be completely separate. And the fact that this became a problem the second he had an attorney to explain to him the whole situation means that he maybe didn't know the entirety of how bad this would be for him. And I worry that Rashbaum was like, it's fine. It's okay with you. It's okay with your mom. It's all good. No, it's not. You need conflict-free counsel to say, this is a problem. Because how do you vigorously and zealously represent, if you're the attorney, Charlie's interest and Donna's interest, because they are co-conspirators and those interests are not the same? You can see mutual defense agreements like we saw between Baldwin's attorneys and Hannah's attorneys, where they can share information. That doesn't stop Baldwin's attorneys from going to court, getting up there and being like, the armorer's the problem. Or the armorer getting up there and being like, well, if Baldwin hadn't done this, he's the problem. They can share information, but they can still point the finger at the other client. If you're Rashbaum, you can't point the finger at Donna or at Charlie because you're conflicted, and that's the problem. This is an avoidable mess that became a massive mess. A massive mess.
I don't quarrel with the general concept that these circumstances ought to be avoided. And it doesn't create these circumstances. Beyond that, though, there's not been an assertion of this. And of course, Mr. Adelson's entitled to change his mind whenever he wants.
And that's the
Change
other
his
problem.
mind 3 hours from now, I suppose.
He could always
I will
assert
take
this is an
Niles'
issue.
presence as proof he's changed his mind.
Yes, sir, understood.
The court's like, yeah, we're there now. Clearly he changed his mind.
I don't think that
I hid my hand lotion from myself when I cleaned my
my
office.
understanding from Mr. Upperman in discussion was that the conflict was strictly limited to Mr. Adelson not wanting Mr. Rashbaum, or potentially by extension myself, to cross-examine. And that was the limit of the conflict, is my understanding.
Ms. Niles, do you need to clarify anything?
I do need to clarify that, Your Honor. Our first filing yesterday, the notice, did frame the issue in terms of concern about
This is Charlie's lawyer.
potential sharing of information on the defense team, right? Mr. Adelson was not waiving his privileged communications with Mr. Rashbaum. But after we read the response from counsel, I think it became clear, based on our reading of the rules regulating the Florida bar, that it would not be enough to bring in a third party, or it would not be enough to have a walled-off attorney conduct the cross-examination. And that's because I read Rule 4-1.9A to control on that issue. So Rule 4- 1.9b says you can't use information gleaned from the representation to the disadvantage of a former client, but A says you cannot advance an interest that is materially adverse to a former client in the same or substantially related matter.
And these are
So whether we
substantially
have another
related because they're the
attorney come in
same.
and do that cross-examination, and I absolutely trust Mr. Morris and not, I'm not challenging his veracity when he says he was called off from this issue, but I don't think it solves the problem, because whether we have another lawyer.
She's arguing, look, it doesn't matter if Morris does the cross-examination of Charlie or somebody else comes in and does the cross-examination of Charlie. The conflict is too great. And ultimately, the court yeeted Rashbaum, but then we just saw a month later yeeted everybody and was like, you're right, everybody out.
Actually conduct the cross-examination doesn't solve the issue of A under that rule. In the case cited in Mr. Adelson's notice called Kolker that Your Honor just referenced, also addresses this exact issue and says having a third party conduct the cross doesn't resolve the conflict because it's the relationship that forms the basis of the conflict, not just the information. So it would be our position that Mr. Rashbaum cannot advance an interest against Mr. Adelson because
Right.
Mr. Adelson is now going to be a witness for the state of Florida. That is a problem under the rules regulating the Florida bar and Florida case law.
And it is.
Well, does any party have anything further they wish to add to this matter?
Brief response, Judge. Of course, Ms. Adelson has a right to counsel of her choice. I recognize that there
It
are
is not absolute.
Understood. I recognize that there are restrictions, but in the circumstances...
The judge's monotone is sending me. The judge is like, that is not absolute. I like this judge. I like this judge a lot. I like the judge's demeanor. I like that is not absolute counsel. And we're seeing, it's so interesting watching this back and seeing that the court's already like, this is a huge issue. Now knowing that a month later, the court's like, you know what? No, everybody get the fuck out. Like, I thought about it. Everybody get out. And it's interesting to see how bad this got. And now Donna gets none of the lawyers she likes. Anna says, so we like Florida judges. I mean, so far the judges that we've had here have been great. The demeanor has been even keeled. I think their rulings on the law have been easy to follow and logical. I think they've run good courtrooms from the judges that we've seen. So yes, even keel. Judge K was fantastic. This judge, from all the hearings I've seen with this, lets the lawyers talk, keeps a tight rein on the courtroom, and has been thoughtful and consistent.
For us, then, Mr. Adelson may not testify in this case, and that's a little bit of the frustrating part, is that this can be utilized as a tactic in some respects.
It doesn't mean he still can't lob a hand grenade in the direction of the trial.
Sure.
And he just did.
The frustrating part, I guess, is that the defense doesn't intend to call him. The state's acknowledged that it would be in rebuttal if they were to call him. And
However, that could change.
I can't fathom why there would be a lot of direct or cross-examination, but...
If this witness cannot be properly cross-examined, your client has lost the right to effective representation, and therefore, we have an issue relating to whether or not a new trial is merited. At the outset, it is foolish to charge forward under the circumstances. I can examine your client if she's willing to waive the issue of the conflict and also waive the issue on appeal. But that still does not per se resolve the matter.
Because Charlie is still the issue.
Examine your client.
May I have just a moment, Judge?
Go ahead.
Danielle asked, are the clients present at these hearings? I'm going to turn this down and zoom. They're going to talk to Donna. Are the clients present at these hearings? Yes, they are. Donna is. Charlie is in custody, but Charlie is not present, though Charlie might be watching from Zoom. Bonnie said, is this a repeat hearing? I have not covered this hearing yet. We were talking a lot about it, so we decided just to play it instead of reading the transcript. Because why not if we can watch it instead of just reading the transcript? This hearing happened September 17th. I did not cover it. I was in New York covering Diddy and going to the Creator Summit with YouTube. So I have not covered this hearing, but this is an older hearing, very much tying into the issues that we are covering now. So Donna's going to be sworn in
If the court wishes to inquire.
to
Please raise your right hand.
to waive this
Do you
again.
swear or affirm the testimony you will give today will be the truth? You can lower your hand.
Ma'am, did you really think that washing money with water was what money laundering was? Don't you wish?
I believe we've done this twice before, but given the circumstance and what has now arisen, it is prudent to do it once again. Do you understand that you have the right to conflict-free counsel? Meaning specifically as it relates to Mr. Rauschbaum or any other conflict that may be imputed to Mr. Morris or any other third party. Do you understand that your attorney has to be able to properly cross-examine your son if he is called as a witness?
Yes.
Do you understand how this conflict affects the cross-examination potentially or your overall defense strategy?
Yes.
Have you been able to speak with a conflict-free attorney in making the decision as to whether you wish to waive any conflict on this matter?
Judge, the short
Have you talked to a conflict-free attorney? And Morris is like, I'm kind of conflict-free, while the court a month later finds that he's not.
answer is going to be no, beyond having spoken with me at the inception of my representation.
Would you like to speak with conflict-free counsel concerning this issue?
Yes.
Very well. Before we finish the colloquy on
She
this
said
matter,
yes.
then, we will go into recess. The defendant will have an opportunity to consult with conflict-free counsel. We'll resume this afternoon. I will finish the colloquy this afternoon. Any jurors that have been summoned this morning will be released for now. And if there is to be a selection, we will get started again at 1:15. Before we finish for this morning, Ms. Dugan, Ms. Keppelman, did you have anything else that you wish to raise or argue?
Nothing
So
else, Your Honor.
bad. This
Very
is so
well.
Your
bad.
Honor, may I be excused for this afternoon, or would you like me to come back?
If there's anything else that you need to raise on behalf of your client,
No, Your Honor, there's not.
very well, you are excused. Please report back at 1:15.
So we're going to
Whoever the
zoom through all the
conflict-free
breaks.
Counsel is that Ms. Adelson will consult with if either she has someone in mind or if the attorneys are going to assist her with this. Please move quickly so she has an opportunity to speak with someone, and we'll move forward from there.
Judge, could Ms. Catwoman and I come sidebar briefly?
Please approach.
All right, this sidebar we actually have in transcript. So I'm going to go ahead and read you this sidebar in transcript form while the court is at sidebar. So the sidebar is the court, Mr. Morris and Ms. Kappelman. The court says, go ahead. Mr. Morris says, Judge, Adam Commissar is the third-party lawyer that I spoke with, and he's present in the courtroom. I say that because from the time schedule, I don't know how long this is going to take, but my suspicion is that consultation will not be necessarily long. The court said, all right, Ms. Dugan, Ms. Kappelman, anything concerning this? Kappelman said, I do want to have an opportunity to confer with my office, but I'm sure that won't take longer than however long this process will take. Do you want to reconvene in an hour? The court said, I'm fine with doing that. It's just at this point, I don't want to charge forward into reversible error. The foreshadowing is strong. I don't want to charge forward into reversible error, and I think y'all know where I'm coming from. Kappelman said yes. The court said duly noted. Very well. What time do you want to reconvene then? 10:30. Should that be sufficient time? The attorneys all say yes, sir. Ms. Dugan said, are we still releasing the morning jurors then? If we do that, the court said the next batch will be reporting at 1 o'clock. So really we're going to, I guess we could either go late today if we can still select it all, but I'd rather not hold them up and just keep them down there waiting. So also they have not been instructed yet. Do not discuss why you're here. And then Ms. Morris cut in and said, let me ask, Your Honor, if the court's headed in the direction of removing Mr. Rashbaum from the case in its entirety, that's probably a different issue than the third party cross-examination, of course. And the court said yes. Ms. Morris said, but I'll have Mr. Commissar discuss that as well. The court said, all right, please do. Sidebar was concluded. The court says we'll reconvene at 10:30. We're in recess for now, and then recess is taken. So we're going to scoot past the recess and come back onto the record with the attorneys in court. At this point, almost 2 hours later, Donna Adelson has spoken with Mr. Commissar, who then became co-counsel on the case and then was yeeted from the case like 2 days later. So we are going back into court to see what happens
Where we were
when they go back on the record.
I believe Ms. Adelson was consulting with independent counsel on that matter. Has she had sufficient time to do so?
Judge, I think I'll let independent counsel, Mr. Commissar, speak to that.
Mr. Commissar?
Yes, Your Honor. May it please the court, just for your awareness, I've been involved in this since yesterday.
He's like, I'm new to this shit show. There are now so many attorneys here. There are so many attorneys in this courtroom trying to figure this out.
She has had a chance.
Welcome.
She has had a chance to speak with me.
The court, welcome to the shit show.
She would not like to lose Mr. Rashbaum. She's willing to make any waivers.
Yeah,
that
she
are
doesn't
necessary.
care.
She's not seeking a continuance, and she's fine with currently unprepared counsel conducting the cross-examination of Mr. Adelson should he be
Yeah,
called.
she doesn't care.
Well, let's go ahead and finish the colloquy that we started earlier concerning the waivers. Ms.
So
Adelson,
now
if you can stand
they're going to
once
ask her
You
again.
have already been sworn. Now that you've had the opportunity to discuss with Mr. Commissar the issues that are related to the conflict of Mr. Rashbaum and also any issues as it would relate to proceeding forward under these circumstances, are you in fact waiving any conflicts regarding Mr. Rashbaum?
Yes, sir.
Do you also waive any issue on a future appeal regarding the issue of your son's cross-examination as it pertains both to the preparation of any counsel who would perform that cross-examination or the fact that it may not be adequate representation?
Yes.
You may be seated.
And again, a number of you said it in the chat, and I agree with you. Why is Donna just like, it has to be Rashbaum, it has to be Rashbaum, it has to be Rashbaum? If Rashbaum is her attorney of choice and she hired him when the investigation went down, because she was listed as a suspect when the investigation ramped up in this case and they started tying things together. So 2015, I think, is when she was first listed as a potential suspect or person of interest and hired, it seems, Rashbaum at that time. If that's true, then Rashbaum shouldn't have been Charlie's attorney without a waiver because he was working with Donna first. And that is a huge problem as Charlie is now appealing on a new trial because he had an attorney who had a conflict. So Donna's insistence of like, it's got to be Rashbaum, I also have questions. But in the jail calls after Charlie's convicted, she's talking about conversations with Rashbaum about how to get out of the country. So Rashbaum, even after representing her son, is still working with her when she's trying to figure out how to flee. It's bananas.
Does the state have anything to raise concerning this matter at this point?
Just that the state is in agreement with proceeding as outlined by defense counsel. In the limited research I was able to do on the issue, it seems like a lot of the times when it goes the other way and the court in its discretion decides to boot the counsel of record for conflict, the state is seeking that. So I just want to put on the record that we are not seeking for Your Honor to do that in this situation.
They're not asking to
dismiss
yeet the defense.
Mr. Rauschbaum.
Correct.
She did her hair for trial, Your Honor. She's
Very
ready to go.
I'm going to perform my additional research.
Look, man, she is ready for trial. She's got trial suit on. She's got jury selection hair going on. Like, the prosecution's ready to start trial.
Before we continue this afternoon concerning whether or not this waiver is sufficient. The defendant has made it. She has made it voluntarily. At the same time, whether it is sufficient to survive any review, that is really where my mindset is at this point. Unless any other party has...
Did you hear what the court said? Can keeping this counsel survive appellate review? And the court's kind of like, I don't think so. I don't think it can. So
something to raise.
the court's going to take another like 2-hour break.
And get started again at 1:30.
Judge,
I mean, the hair is given.
Ms. Niles, in speaking with her during the break, is she and Mr. Upperman are meeting with Mr. Adelson because the question has arisen as to whether or not there's a conflict as it relates to cross-examination, or if Mr. Adelson were to have a continued objection to his representation, continued representation of Ms. Adelson. I think that there's some thought that that needs to be confirmed from Mr. Adelson first, because if he takes a different position, it would seemingly disqualify Mr. Ashbaum altogether.
Right. And Morris is like, I see the problem.
I wanted to let the court know that that's in the works.
Good.
Also, as it relates to the waiver, so the court was aware, and there's mention of it in the comment section of the rules regulating the profession, that an oral waiver is acceptable.
Morris is now
appropriate
concerned.
with certain conditions that are set forth in the rule.
Is the attorney who obtained the waiver available to speak on this matter?
I don't know the answer off the top of my head, but
Rashbaum stood up.
I say within 99% certainty we'll facilitate it.
And Rashbaum stood
Does
up.
Your Honor need, that's why I'm mentioning this. Should I?
Rashbaum's like, Morris,
Excuse me, Judge.
yo, it's, it was me.
And then the independent waiver did not get a signature, but he could testify as an independent.
He said, it's me. It's me.
Does Your Honor feel like you need to hear from me?
So we have a fully developed record? Yes.
Okay, let me make arrangements during the break, and I'll alert chambers as to how quickly we can do that, so we don't waste time this afternoon if possible.
Please do.
Yes, sir.
I'm going to
Please
have the
do.
afternoon jurors report at 2 o'clock, so that way no one's time is wasted while we're going through these matters. Mr. Commissar, you had something else to add?
Yes, Your Honor. Just as we're talking about perfecting a record, I just wanted to note that as the independent counsel, I was given an opportunity by the court to meet with her independently. The bailiffs gave us some privacy here. I was able to meet with her for easily 30 minutes, and I'm not revealing any of our confidences, but this was not a squishy situation. Once I was able to articulate the options and how they can result in delay or the opportunity
She's like,
to prepare.
Rashbaum, Rashbaum, Rashbaum.
Was a strategy decision that is being made by a defendant who does not want to delay their case, but understands that the representation they're going to get from my cross-examination is not what they might get from another lawyer, or definitely not what they're going to get from me with a year of preparation. So it may look odd in a cold record having a lawyer come in this morning and advise somebody to waive such an important right. I was able to articulate the options, but I did not necessarily advise somebody to waive their rights.
He's like, look, when he says this isn't squishy, he's saying the defendant is like, let's ride full steam ahead. He's saying this isn't a situation where the defendant's on the bubble. There's no wiggle here. Donna Adelson's like, I want my trial. I want it today. I want it with Rashbaum. I don't give a fuck who cross-examines Charlie. It's going to be fine. I want it to go forward the way I want it to go forward. I want my trial now, Your Honor. Now with my lawyer. I want it now. And the court's just like, yeah, I don't think that's going to happen. So when he's saying it's not squishy, what I think he's trying to say is this defendant is incredibly focused and determined on what she wants. And does that surprise us?
Mr. Morris, do you wish the court to engage in any further colloquy with Ms. Adelson concerning this matter?
Not at this point, Judge.
Very well. Ms. Adelson, I do not want you to respond, but I want you to understand, although you have made an affirmative waiver On these matters, I still have to evaluate whether that waiver is sufficient or whether Mr. Rauschbaum needs to be terminated from this matter. I'm going to give this serious consideration. I will do additional research of my own from there. Everyone will have an answer this afternoon. We are in recess until 1:15. Please come back to the courtroom at that time.
Judge, would you be open to both sides submitting case law for your consideration during the
He's like, I am open to all of you figuring this the fuck out before we have jurors showing up to the courthouse.
recess?
Certainly.
Ooh, the judge is like, y'all are the worst. The judge is just like, you are the worst. All of you, the worst. All right. They're going to take a like 3.5 hour break. We're going to just skip all of that and come back as the court's coming back onto the record to make his ruling. The judge went back and did his research. This again was the day that jurors are arriving. This is the moment that they are supposed to be going to trial. And when the court said early on in this proceeding that Charlie Adelson has every right to kind of throw a grenade into the proceeding, that Charlie Adelson has that right. And I think it becomes more clear now that Attorney Rashbaum never got a full waiver from Charlie, but even if he did, that can be withdrawn. Charlie can say, no, you know what? Now that I've talked to independent counsel, I'm not waiving my right. This attorney represented me. You and your defense team cannot cross-examine me. Not a chance. So let's go back to court after an extended break where the judge was doing his legal research, jurors were coming to the courthouse, and the rest of it, and get right into what the court rules. There isn't too much left of this hearing, to the best of my memory, but we'll see. I think I only saw parts of this, again, as I was in the back of an Uber in New York trying not to get motion sick by being in the back of an Uber.
Good afternoon, everyone can be seated.
So we are now back in court after an extended break. Oh, Casey Cat, thank you for the gifted memberships.
I'm almost scared to speak. Does anyone have anything to raise before we continue forward?
Judge, may I approach the lectern?
Yeah.
I'm almost scared to speak. Oh, Your Honor. Oh,
So,
boy.
Judge, with the surprise issues of the last couple of days, I have asked for my prior client's waiver again.
This is Rashbaum. Remember, Rashbaum is now at the lectern. Charlie's in lockup. I don't know if he's in lockup at the courthouse or if where this court's located, the lockup he was transported to is close. But sometime over that extended break, Rashbaum went to go chat with Charlie. And we're going to hear about how that chitty chat went.
And with the change of circumstances, he has decided not to give it. So let me be clear. I have a waiver in the past. It's from December 12th, December 13th, and an independent lawyer spoke to him as well, although did not get a signature on the waiver. So we had a waiver. We thought we had a waiver. We didn't think there was an issue. But given the events of the last 2 days, I approached appellate counsel to get a new waiver. Thought that was the right thing to do, obviously.
And
the
appellate
cleanest
counsel
thing
was
to
like,
do,
good
and,
luck.
I am not able to obtain that waiver at this point. So as a result, I need to withdraw from the case.
Very well. Does the state wish to be heard concerning the withdrawal of
Not
counsel?
going to be enough.
I don't think I have anything appropriate to say on the matter.
I don't think I have anything appropriate to say. What I think the prosecution means is this is none of my fucking business. I have nothing to say, that I have nothing to add. This is all between all of you. But I think the prosecution's internal monologue is, you motherfuckers. Are you kidding me that we are getting here to the day of trial and this is exploding? We are ready to go to trial for like the 5th time in this case. Are you fucking joking me that we're here? But this is where we're at, and there's nothing that you can do, which is why you can plan as much as you can plan for trials, but stuff happens. And the prosecution's like, we knew this was an issue from the beginning, but are you kidding me that Charlie is now like, this is a huge problem? And again, I wonder if it's because this is the first time Charlie's actually had independent counsel, his appellate counsel, talk to him about why this is a huge fucking problem.
Your Honor,
Well
what
put.
we need to do, we would like to proceed, and
She says, I have nothing appropriate to add, and the court said, well put. The court's pissed.
I don't think I have anything appropriate to say on the matter, Judge. Your Honor,
Well
what
put.
we need to do, we would like to proceed, and I'd ask Your Honor to inquire whether we can proceed with second chair.
Well put.
Representing Ms. Adelson, but
Mr.
obviously we're ready for trial and there's a lot at stake.
Mr. Morris, are you prepared to move through this trial without Mr. Rauschbaum?
Yeah, no.
I tried to think about all of the different potential rabbit trails, and the short answer is I do not believe that I am going to be able to be adequately prepared to proceed forward with the present calendar, primarily because of the division of labor in the case. I would move to continue for a brief period of time. That's also, in speaking with Mr. Offerman, which is an issue that I'm going to request that we address, the objection by Mr. Adelson would still pertain to my cross-examination, and by extension, the third party would conduct cross-examination. In short, I need time to regroup.
Yeah, I bet you do.
Before we finish today, I will have the in-camera hearing review concerning whether you have been properly walled off. As to the withdrawal of lead counsel, I am going to permit it. The conflict issues are so severe.
By the way, the withdrawal of lead counsel is I quit before you can fire me. Like, the court was going to remove him either way.
I am going to permit it. The conflict issues are so severe, I believe, to move forward with the trial. Ms. Kappelman, Ms. Dugan would place us in a position where we would end up in a reversal. Let's go ahead and set a case management
This is reversible
date
error.
as to all the expense that has been undertaken with moving.
This is basically all the court can do right now. And this is the court saying, this is the most I can do right now. And then a month later, of course, he gets rid of the rest of the defense team. But this is the court letting you know how mad he is.
In a reversal. Let's go ahead and set a case management date as to all the expense that has been undertaken with moving witnesses and preparing for trial. The state certainly, as a part of any cost of prosecution, if you are successful, may seek those costs as it relates to today, as this continuance will be charged to the defendant.
So when the state goes forward with the prosecution, all of the charge for delay, they can charge to the defense. That includes moving multiple people from prison back into state custody. That means the cost of subpoenaing witnesses, any witness travel. So the cost of the false start, the state can apply for those costs, how much it costs the state to get ready, and charge that to Rashbaum and be like, no, this is getting charged to the defense. So all the practical costs, the subpoenas, the time for the subpoenas, potentially the cost of bringing in the jury panels, the cost of transporting everyone across the state or out of state, because prisoners aren't always housed in state, transporting them, housing them in state, all of those costs can get charged to the defense, and the state can apply for that later.
As to a new date, when would the parties like to have a case management?
I think as soon as possible, Judge. I'm prepared to brainstorm with Ms. Kappelman and Ms. Dugan with the state to be able to get a trial date if we wanted to do that. But I don't know if we need additional time.
Ms. Dugan advises she has a court date October 15th.
So they are now looking for a date. It got set and then it got bounced. So they set the date and then it gets bounced. And then they do the in-camera hearing that we
Porter can meet me in the
heard
jury
about.
room. Mr. Morris, please as well.
The judge's face is like, I'm mad and disappointed. And Donna is pissed. But this is Rashbaum's fault. This is Rashbaum's fault. And there's nothing Donna can do. And I don't know if Donna's used to there's nothing she can do. There's nothing she can do. There's nothing she can do. There's a conflict. Charlie's not waiving the conflict. I want to know if there's jail calls. Are there jail calls between Donna and Charlie after this? God, I would love to be a fly on the wall. Can you imagine? Or jail calls between Donna and Harvey after this happened? Ooh. Can you imagine? Because I think Donna is fucking livid. Livid that she's not getting what she wants here. So. And yes, Seven Dogs asks, is Donna in custody? Yes, Donna is in custody and remains in custody until this goes to trial. Has been in custody since she was arrested at the airport. Morgan, it depends on the jail, but people will try to do three-way calls where she would call Harvey and then Harvey would call Charlie. People try to do that. It's not always within the rules, but it happens. But I am curious. So Donna, not a happy camper with her attorneys getting yeeted. And then I imagine, you know, Mr. Morris is like, yeah, but it's okay. I've got you. And then a month later, the rest of her attorneys get yeeted. No, she has got to be, Persephone in the chat said she does look quite shocked. She has got to be stunned that this is happening because they got up to this point knowing it's a potential problem, but she's like, I've waived it. I'm sure Rashbaum said, and Charlie waived it. I would imagine from Donna's perspective, and this is me speculating, that she is like, how is everyone doing this to me? Why is everyone doing this to me? How can anyone do this to me? Why is this happening to me? But also, she is in custody. She is on trial for murder, conspiracy to commit murder, solicitation to murder. She is with an attorney that she trusts, and she is losing the attorney that she trusts. And I am sure she is livid. And the problem is, though, this was always a possibility. Her lawyers should have told her this was a possibility. And her lawyers shouldn't have gone forward from there. Shazam said, EDB, you have a new emoji under your name on the screen. It is not a peach. It is a jack-o'-lantern. So it is a Halloween emoji. We were ready for Halloween, both the movies and the Dave Matthews Band song. So Donna's pissed. They do an in-camera hearing with Rashbaum. He gets removed. Everybody else gets removed. But also, when you want somebody to be in your corner, I can understand that it's upsetting to her. I think she's also probably a little scared because now what? And I saw some of the practical questions. TX Boy Mom, does she get a refund from that attorney? Not from what was already spent. No, because they did the work. Could she go after this attorney later for fees? Maybe. But again, trusting your attorney is hard. And this is somebody who's walked with her since the beginning of this. So this is an attorney that has been with her since the beginning. And I can understand how disorienting that would be. She should have known, though, that this was coming. And then to find new lawyers while you're in custody that you haven't talked to before, is gonna be frustrating. But her husband's still out of custody. She has money to hire a new attorney. There are, I am sure, very competent public defenders in the area. I don't think she would qualify for the services of the public defender, but if she cannot find an attorney, they can appoint one and then charge her for it, or a panel attorney. But she is mad. Katie Gray said, why were her lawyers removed? Conflict. So that's what we've covered most of today, is the conflict with the lawyers. The thing that's frustrating to me is all of this was avoidable. All of this is avoidable. All of this is avoidable. And the judge was like, yeah, the conflict is, the judge said at the beginning of the hearing, the conflict is as plain as the nose on my face. And so with all of it, it's going to be a problem. Creekside Counsel said, why does Charlie get the attorneys and not her? Well, that might be a problem too. Charlie's appellate attorneys are saying that Charlie never waived the conflict because these attorneys worked with Donna before his trial, but he went first. So that's why it has now come out after this hearing that Charlie never waived the conflict that Rashbaum had worked with Donna before he represented Charlie. And that is going to be a huge problem. Charlie might get a new trial on appeal based on that issue, and is asking for a new trial on appeal based on that issue. She wanted this attorney. She wanted to go to trial on this day. And I think she thought it was all fine and that her son was fine with it and had waived it. And that's what Rashbaum was telling the court. Charlie waived this. And it's like, right, he doesn't now though. He doesn't waive it now though. And that's his right. So I put a lot of this on the lawyers. This is not good client management. And where this case goes from here, man, where this case goes from here, we will see. But we are more than 10 years out from this homicide. And I'm sure for the victim's parents, it is just a very, very long 10 years. And the prosecution is going defendant by defendant by defendant. Basin said, wait, you can change your mind. Yes, you can change your mind on waiving it, especially when new information becomes available. Yeah. How does she find a new lawyer? Probably asking Rashbaum who he would recommend. So probably asking Rashbaum. Ray Phillips said, how many lawyers has Donna been through? Well, she had Rashbaum, he got yeeted. She had Morris, he got yeeted. And then Commissar came in and got yeeted. So 3. Now 7 dogs. Are there any repercussions for these lawyers? We will see. Gino said, has Charlie thrown her under the bus? I don't know, but I think the boundary that Charlie's appellate lawyers asked him for, which was you can't waive this conflict, is appropriate. So Nishay said, what is the conflict? I'm confused. This attorney in the same chain of events worked with 2 different defendants who might have opposing and different defenses. You cannot represent both. So the judge is done talking to Morris and is now going to talk to Donna, who's clearly quite upset in court. But you can't represent both. And this is a conspiracy case and a solicitation case. The best defense for each of these defendants might be some other dude did it. It might be the other one convinced me to do it. But one attorney cannot well represent both of those positions because you can't take a position that opposes the interest of your client. Shazam, counsel had to see this coming. And how did counsel think it would be fine is my question. How does counsel think it would be fine? I don't know how counsel thought this would be fine. I don't know how they thought that any of this was going to be okay. So Charlie's appeal actually raises some good issues. So when the court comes back, which is going to be in just a moment, so I'm going to zoom to the court coming back. He just puts us over for another date. That date got yeeted because the other attorneys got yeeted. But there are, conflict doesn't come up at this stage in cases very often because normally conflict comes up early on. The conflict is resolved and it moves past it. This mess is actually a mess. And Donna has the right to conflict-free counsel, and so does Charlie. And Charlie's like, I didn't even know. Bree Warrior said, why didn't the state say something sooner? The state thought that it was waived as to Donna because she kept waiving it in court. I don't think the state knew that Charlie hadn't waived and that Charlie was withdrawing waiver. I don't think anyone knew that Rashbaum worked with Donna during the investigation before Charlie was arrested because Charlie was arrested first. I don't know if anybody knew until appellate counsel brought it up 3 weeks ago. I think that was last week or the week before's Quick Bits over on the Quick Bits channel. So when's Charlie's appeal being heard? It's in the early briefing stages. So we don't even have a response yet, but it's a problem. Anna said, Emily, Friday, Tuesday will be a short stream. I just love how Emily loves spending time with us. I do. And then when we got to the fact that we had a transcript, I was like, well, we can just watch the hearing. And then you guys were like down and then we're down. So there we go.
Has concluded It's in-camera hearing with formal counsel and remaining counsel, Mr. Morris. Mrs. Adelson, depending if you choose to hire additional counsel or just reset the trial date, you'll certainly be able to work with Mr. Morris as your attorney in making that decision. But the trial is going to be continued from today. The jurors will be released this afternoon. Again, as to the inconvenience and delay that this has caused, I'm not happy, but at the same time, we're trying to get this right so we do not have to do it a second time. I will speak with the parties again when we have the next case management hearing. We are in recess.
I'm not happy. The final words of the judge, and you know he's not happy. Lovely Hope said, did the state know about the conflict when he represented Charlie? I don't know if they did. I'm waiting for the response to the appeal because I don't know if the state was aware. There's a lot I want to see in the response to the appeal on that. So I'm waiting to see the response on appeal, but based on what happened here, if it's true that Donna worked with Rashbaum, and I think based on everything we've seen, I'm not surprised by that. She was completely comfortable with him and chatting with him on the phone. I wouldn't be surprised if Rashbaum is a lawyer that she had known for a while. Her daughter's also an attorney, called him when she found out or thought she might be a suspect, or even when Tallahassee PD at the funeral was like, hey, we'd love to have a word with you. The first thing she did was call the lawyer. If she initiated that with Rashbaum and they were the ones talking back and forth, then yeah, it might be that there's a conflict as to Charlie that was never brought up. I don't know if the state would have even known that. So Casey Katz said Rashbaum admitted he never got a signed waiver from Charlie. And that signed waiver from Charlie Rashbaum was talking about in court was as to Rashbaum representing Donna. I think it goes back even further than that, and it's going to be a huge problem. I think it's going to be a problem. So I saw a couple of you asking in the chat, could there be a plea deal? Always. We saw the prosecutor saying we're always open to conversation. It seemed that Rashbaum wasn't interested in that. But was Rashbaum not interested in that because they'd want each client to share information on the other ones? That's why a conflict is such a problem. Aeon X said, why did this take 10 years? Was it a cold case? No, the investigation took a while, but they did the trial of the gunman, then the trial of the the go-between, and then the trial of Charlie. So they've been going trial by trial, but some of the trials took a while because of investigation, because they needed cleaned up audio and stuff like that. So it's been staggered. So yes, Moya said nearly 10 years. Yes, the homicide took place in the summer of 2014. The first prosecution and plea weren't until 2018? We went over that earlier on. So it's been going person by person. So with all of this, it's going to be a problem on Charlie's appeal. It's a problem for this trial. And now there will be a new pretrial hearing in December. And this trial might go sometime in 2025 because after all of this happened, new attorneys just signed into the case on, let's see what day they filed this real quick. New appearance of new counsel signed, filed this on October 22nd. And the court said, fine, you can be new counsel, but you need to be up to speed by the time we get to the pretrial conference on December 10th. So you've got like TikTok, you've got like a month and a half. So let's go. So there are now new attorneys that have made their appearance as of October 22nd and have demanded all discovery. Remember, the court said you can turn over discovery, but there can be no notes, no conversation, nothing. It has to just be the files. So with all of it, let's see if we can summarize the mess that's going on in the Adelson case with everything that we covered today. So at the end of the day, Donna Adelson's attorneys, all of them were kicked off the case, and on October 22nd, new attorneys made their appearance. There will be a pretrial, it's not even a pretrial because there's no trial date set, a case management conference on December 10th to see how long it will take entirely new counsel to be ready for trial for the trial of Donna Adelson, all while Charlie Adelson's appeal is pending. In his appeal, he argued that because there was a conflict with Attorney Rashbaum, the one that was removed off of Donna's case, because there was a conflict with Rashbaum at trial, Charlie's arguing that he is entitled to a new trial on appeal. And there are issues here. We also, at the end of the hearing, heard that the court stated that the delay will be charged to the defense, and after the prosecution of Donna, if the prosecution is successful, the state can move for cost from the defense for the cost of delay for not being able to move forward with trial on September 17th. So the Adelson case is a long way from done for both Charlie and for Donna based on the appeal and based on the pending trial. I'm wondering if we will see them be tried together in the future or not, but 10 years after this murder, for this to still be going through courts has got to be tremendously frustrating for the Markell family. And the more that keeps coming out, the wilder it is. They are still serving search warrants for more information. So if Charlie Adelson does get a new trial, there might be even more evidence against him because the investigation is still not done. They are still going through digital evidence for the state, and there are still new things being unearthed. So this is going to be a lot when it finally goes to trial. When will that be? We don't know. Am I keeping an eye on it? Absolutely, because these conflict issues are very real and very much a problem, and I'm curious to see what the appellate court does with that. It's going to be a problem, and that's going to spend a lot of time and money for everybody. A lot of time and money for everybody. Let's get to questions real quick, chat. And by quick, I mean speed run, because I realized I have a meeting in like 5 minutes about some stuff that we are bringing to the Law Nerds very, very soon. So when I said, let's do this because reading it will be slower, I think we're all good with it, but we'll get to just a little, we'll just get a little bit more. Natsuki asked, was the victim's wife in on the plot? Don't know. It seems that Wendy had been granted some type of immunity. So we don't know. I don't think we'll ever see Wendy be charged. Patty Garner said Rashbaum should be held accountable, in my opinion. I mean, being charged, the delay will be an issue. And then we'll see if Charlie Adelson or his lawyers make a motion about that. So we'll see. Sue, thank you for the gifted memberships. Robin Lynn said, could this all be a stall tactic? I think that Donna really wanted and was ready to go to trial, or at least that's what it seemed like in court. I don't think this was a stall tactic. I think that Donna, this is completely my speculation from watching this case. I don't like to speculate often. We will speculate here. I think that Donna and her lawyer never thought this would be a problem. Like, never thought this would be a problem. Never thought that Charlie would have an issue with it, thought that it was just all good. I think they misread the situation. I don't think they wanted this delay. I think Donna wanted to go forward with these attorneys. I don't think she cared what the potential conflict was. These were the attorneys she wanted, and she wanted to go to trial with them. So I don't think it's a delay tactic. I think it is it's going to be fine. It's all going to be fine. And then Charlie was like, it's not fine. So I think appellate counsel and Charlie had some very real conversations after his conviction. And I think Charlie went, oh, that is my supposition on all of it. Sarah said, been following from the beginning, hoping justice for Dan Markell comes one day. I feel for his parents. This has got to be gutting to go through this for 10 years while fuckery is still happening. Miss Ryan said, hi, Emily and Law Nerds. Today is my birthday. Happy birthday to you. Happy birthday. We would sing all of the 50 Cent, but meeting. Rashbaum stated he never got a physical signed waiver for Charlie. With regard to Donna, he did state that in court. I don't think we've heard him talk about whether or not there was a waiver even earlier on. And I don't think there was one. I don't think there was one. Thank you, Chris. I might be a moment late, but I will be there. So do not worry. Casey Cat said, I'm behind and lurking, but did the court actually tell the defense to go to YouTube and roll that beautiful bean footage? No, they didn't. But the defense told the court, we don't have the official transcript, but here's the timestamp on YouTube. It was the other way around. Roll that footage. Will Donna put out an ad like Sarah Boone? No, I think she probably asked Rashbaum who he would recommend. Matt Bond, good to see you in the chat. Well, hello, my spiffy legal mumbo jumbo talkie sister from another Mr. How I Have Missed Thee. Matt, good to see you in the chat. Good to see you. Dawn Whaley in the chat said, hey, EDB, I was deposed last week and your trial commentary about good, bad testimony was incredibly helpful. Yay! I kept saying, what would EDB say in my mind the whole time? Look, it's hard to focus and just hear what's being asked and answer just what's asked, not what they mean to ask. You can't guess at what's being asked. You just answer what you know, what you saw, what you did, and just what is asked. So that is fantastic. Jazzy Zombie said, what's the first thought the prosecutor has when there's a new trial, like potentially in Charlie's case? I would imagine if the prosecutor found out that Donna had hired the attorney first, the very first thought would be, you've got to be fucking kidding me. Something along those lines. You got to be fucking kidding me. Retrials are hard. Retrials are messy, but they've done a lot of these trials. So retrials are messy. There's a lot more. Didn't you say this last time? Didn't you say this time? And now we've got there's 3 trials, or there's been 3 trials in this case. And if Donna goes first, then there will be 4 trial transcripts for some of these witnesses. It's tough. It's tough. So Rue said Anna Kendrick is always the answer. I mean, Kathy said, EDB, love your cursey words. Proud to be a law nerd. I'm proud to have you guys as a law nerd. Jennifer White said, love food court. Can't wait. Yay for Tuesday. We are doing food court on Thursday. Members in the Law Nerd Lounge and on the YouTube channel, I will put up a post. I'm going to ask you if there's anything that you've been waiting for me to cover on food court. So we will be doing food court for Halloween on Thursday. So come festive. We're going to spend a little morning time together on Halloween, and we've got some plans for next week as well. So we've got lots to do. Spiteful Pelican in the chat said the first trial for Catherine was a mistrial. So 4 trials. I mean, that's even worse. That's even worse. And Nishay said this has been way too long. It's been way too long since we've done food court. I agree. So we've got lots of food court. And I have to peek back in on that 50 Cent case, even though it's not technically food court. Maybe that'll go to music court. But we've got lots to do with food court. Is Lunchley being sued? If Lunchley's being sued, we'll talk about it. Griffin asked me about it yesterday. He's like, have you talked about Lunchley yet? I'm like, are they being sued? He's like, I think so. I'm like, I don't know. Maybe they are. But chat, I have got to bounce to a meeting. I appreciate you. Aaron, the Hermes antitrust is on my radar. I don't know when we'll get to it, but it's on my radar. So with all of it, law nerds, thank you for being here. Mods, thank you for riding. I will see you guys on Thursday for a festive Halloween stream. And then we will get back into regularly scheduled programming next week with the quick bits and the podcast of all of it. But for now, take care of yourselves. Early voting is open in most places if you want to get that done before next week. And I will see you, well, on Thursday for food court. Bye, y'all.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.